So I hope everybody had a good holidays. I'm just going to let you know what our plan is, and if somebody has something they want to raise before we get started, I'd be happy to take that on. But our plan today is to go through a number of the things that, and actually Tom's going to lead us through that, a number of the things that we discussed last time that we didn't really come to a conclusion on. And then we'll pick up new topics that we had talked about during the first meeting. The goal here is to hopefully get most of the talking done today. And before our next meeting, which is February 3rd, we'll have a draft of a report sent to all of you that we hopefully can discuss on the February 3rd meeting to figure out what we're going to propose specifically, and then give it up to the governor's office. There'll be time after that meeting to make comments as well and make changes to it if the need be. But I think the next time is going to be our last meeting unless it's absolutely necessary that we have another one. So is there anything else before I hand it over to Tom? Okay, Tom.
So I sent you all a list of the items, the first 11 items were things we discussed at the December 8th meeting, that there was still some. I think the only thing that we completely resolved was the general rulemaking. Everybody seemed to be fine with that, and there was no further discussion. So the next 11 items are matters that, for one reason or another, we held over for some little further discussion. The first item is the reorganization of the ABC law, and I believe the only thing, we had at least a concept put out that nobody seemed to have a problem with, but there was some discussion about maybe using this as a way to change some of the names of some of the section numbers and so forth. And I think that's why we held it over for further discussion on that topic. I think, I don't know if it was Kevin or Rob, you had raised some issues about even renaming things. I just don't.
Yeah, I think like we said, rather than calling it a special license, which is very, it's just it's a license for an establishment generally known as a bar or tavern, rather than calling it a special license. The section that's restaurant hotel could be entitled for an establishment generally known as a restaurant or hotel. I mean, just using some plain language so that people aren't thumbing through trying to figure out, where do I look if I want to apply for a bar?
Excuse me. So what's the drawback of that?
Other than creating more work for me when I'm drafting it, that might be kind of tied in with the second item, which was the consolidating the licenses. I think if we do, at least with the on-premises licenses, if there's a consensus, and I know we held it over, I can't remember why, but if there's a consensus that we should consolidate the retail licenses into one liquor license, then that might just solve that problem, because then you just go to that section for the on-premises liquor license and say, okay, well, there are the businesses that qualify, and we're good to go.
That's right.
I thought you were saying you had no, so that was a yes, no, okay.
You might also want to be consistent to include the wine licenses as well, especially the special.
And that's what the discussion we had was taking the retail on-premises licenses, and rather having the 8 or 9 or 10 different licenses, you have one on-premises beer license, one on-premises wine license, one on-premises liquor license, and then within each of those sections, you would have the various types of businesses that are currently allowed to have the licenses. Instead of having 4 500-foot laws, you'd have one, not 0. You'd just have one. But
drafting error where it's left out altogether.
But that was the thought. So, yes, Mark.
One note you had mentioned last time was the soju exception. You wanted to sort of filter that through the system, and that Mr. Bookman had raised about 1069. That's why it wasn't. That's what's left off.
I've got 1069.
Soju product it's unusual that it's a product that will not be sold in certain on-premise licensees, yet it can be sold it because they're exceptional to the law. We didn't know how to know that. That's why we hold it open.
I'm guessing the way to do that would be just under a generic on-premises wine license statute to just indicate that only the restaurants can sell that, unless the group was leaning toward just expanding it to allow all on-premises wine licensees to sell it. Does everybody know what we're talking about? No. Okay. All right. Under Section 81, which is the on-premises wine license, restaurants can sell soju, which is a Korean liquor. So it's the one exception where a wine license can sell a liquor product. If there's a consolidation, it's not available to tavern wine licenses, the ones that are licensed under Section 81A, the special on-premises wine licenses. It's just the restaurants, the hotels, the catering establishments. So the question would be, if we combined all the wine licenses into one section, would you expand that? I think that's where you're going, right? Would you expand that to include would the tavern be allowed to sell soju as well? Or should it just be kept as a restaurant-only privilege?
Let anybody sell it. What's the difference? Soju is a spirit. It's a Korean spirit, right?
A bar, so bars can't sell?
Just to clarify, there is some debate by the distillers, the craft distillers and farm distillers in particular, about the definition of soju in New York law. Soju is a pan-Asian distilled spirit. It's not just Korean. It's in Japan, it's shoshu, and various different places. And so the way that it's defined in New York state law, it cannot be made by a New York farm distiller and sold in New York beer and wine licensed taverns and on-premise accounts. And so we're sort of excluded from that whole market. We could be making it here and selling it to them, but we can't, under the current definition.
Then I'm in favor of changing the definition.
Why don't we do a two-part thing where it could be made and sold, made here and then sold?
Which is probably better.
Probably better.
Yeah. Just to be able to, it's my understanding that soju has a federal TTB definition. So if you wanted to do this, what you would have to do is give a definition that wasn't the don't call it soju, call it something else, and describe it as any beverage that is made like this, because what happens with a lot of these things is that the name has to come from a particular area. For instance, Scotch has to come from Scotland.
Well, and the statute does, it refers to a Korean alcoholic beverage.
Right.
Certain alcohol content.
Which is the only reason that I said Korean, because I don't know what soju is and never tasted it.
But the real adjustment would just be to add the Japanese and Chinese and Korean versions to the list in the law, because the way it's defined in the law, it's very specifically a Korean product.
And that's the reason you can't make it?
And that's why we can't make it, as farm distillers.
Well, the other reason is because the statute talks about an imported Korean.
There again, okay. And it's problematic because it is a generic term. It's not specific to Korea. It's made all over the Asian area. We'd just like to take that into consideration if you're changing that section at all. Not to disagree with you, but I believe that you're incorrect. There is no TTP definition for soju, but we can check on it. But the last I checked, there was none. So.
All I'm saying is, at the end of the At the end of the day, my vote is that if wherever we come out with that this product can be sold, there is no reason to limit it so that New York producers can't do the same thing that other people are doing. To have a law that says that this product can be sold, but not if it's made by New York, is not in keeping with the governor's idea, and is not really good for the state or the people of the state. Whatever is being sold, it should be able to be made in New York if New Yorkers want to make it.
Just to make a comparison, it's not unlike,
It's called How Do We Make Scotch?
well, I was just going to say that, the fact,
Scotch.
that's
what
it.
we do. We make whiskey.
Whiskey is the general
Bourbon-
category.
Bourbon is a
So you're,
whiskey.
I understand, so you're saying call it something else.
Well, yeah, you call it by its ingredients and how it's manufactured. You don't call it soju.
Yes,
Ralph, isn't it a low alcohol?
it is a low,
spirit? It's not.
it's,
Yeah, that's why.
it's like a low alcohol content vodka.
That's why it's in this odd position.
That's right. Right. It's generally not above 30%.
Right. But the statute caps it at 24. Mark, you've been raising your hand up down there.
It's in this position because there was a specific effort by the manufacturers to create a specific exception.
So it's a very unique exception that was created. You don't want to open up a loophole where all spirits are being sold by one on-premise license, unless you want to do that as well. So the definition of soju is not necessarily federal. It really mimicked legislation that was California-based. The New York legislators saw it. The same people promoted it in California came to New York. They were successful with the New York State legislature, and that's why the product is available in that fashion. And it's not just craft producers that are prohibited from making it, it's any domestic producer. It's just not the only product that's allowed. That's the only exception is for the imported product. If you want to broaden it, by all means, but it's not unique just to New York. It's everywhere.
And to Mr. Bookman's point of why not let it be sold in all the restaurant wines, then soju is served as a supplement for vodka, and mixed drinks and cocktails are made, so then you're expanding where people are drinking cocktails.
No.
Heavy, alcohol property wine.
So what's the consensus here on?
I think if it were possible to say that, just simply add text that says New York
Farm distillers made by, in Korea or by New York State farm distillers.
I don't think you can do that.
But I'm not a lawyer, so I can't really suggest the text, but I'm
No, you got to make it available to everybody.
You have the Granholm problem. So, you either say, we have two different issues before us. One is the issue, should it just remain limited? And the other is, should it be expanded so it doesn't matter who makes it? But you can't say Korea and the United States and New York. You have to.
Right. But my other concern is it also is going to affect the consolidation of these retail licenses. Right?
It's only,
The only question with respect to the consolidation is if you're combining section 81 and 81A, this exception is not in 81A. So are you can create language that makes it clear that only the places that were qualified under 81 would keep the exception. That's not a problem. Right, that's easy enough if we want to keep the exception. To be honest, I think it's a harder problem expanding what it is, because right now by statute it is an imported Korean beverage, and if you take out the word imported and the word Korean, it's a kind of a vague definition of what the product is.
And I'm sure there are
It is.
people that are not going to agree with that very
Right.
strongly.
But you might find about 110 of them in New York that will agree with it very strongly.
So with respect then to the soju exception, is the consensus just to keep it the way it is with the consolidation of licenses, or do you want to expand it to all the on-premises wine licenses?
I keep it and
Keep it the way.
do drafting
Okay. Anybody else had
complicated.
or any other comments about the consolidation of the on-premises licenses? With the understanding that there would be no substantive changes in the privileges or the restrictions on the licenses, just putting them all in one place so that, given the example that Mr. Bookman gave, if I want to have an on-premises liquor license, I can just go to one section rather than going to 4 different sections and figuring out which license I need. I'll take that as everybody's okay with that. Okay. The third item on the list was the importer's license. I think I'll turn to Council Flood because she has more information on this than I.
When we last spoke, there was objection to naming an exclusive distributor, and we can just remove the exclusivity part so that there is a license for people who are importing product and simply selling to wholesalers in New York State.
With that, right? Right? No.
What I suggested the last time, and I feel the same way now, we have 101B that sets forth the rules that as to when somebody's exclusive and when somebody's not exclusive, and that is an election that is made by the supplier, the owner of the trademark. And if we are going to have these people, which I do not object to, this license, in fact, I'm in favor of it, it should be subject to 101B and follow the same rules as 101B.
Yes, but it wouldn't be required.
No, it wouldn't. It's not required under 101B now. It allows the supplier to designate or not designate as the supplier chooses.
That's what that's the intent, right?
Yes, 101B would still apply, so if they wanted to be exclusive, they could. And it would be graduated depending on how many brands the importer had, as opposed to one small company that has 2 brands, as opposed to large companies that have hundreds of brands.
I don't care, okay, but I would point out to you that when we discussed this the last time, the purpose that we discussed was that there are people who have been moving their businesses out of New York because they would like to be here, they'd like to have this permit, but we have these very expensive permits to have it, so they can move to Connecticut and just have an out-of-state shipper's permit in Connecticut and not have this, and we wanted to try to stop them from moving out by saying we're going to, the original idea was, if your idea is that you're going to be in New York, you'll only sell to other wholesalers, you won't sell to retailers, we're not going to charge you a lot of money to stay here. If you graduate by the number of brands, you're probably going to push out the very people you're trying to pull in. So it doesn't matter to me, but it does seem to me that if you're going to say, here's this person, we're going to let them be here, they can import into New York, but they're going to give it to another wholesaler, and we're going to make this inexpensive license to attract these people or let them stay here, why say the number of brands is going to increase the cost?
Because it's still much less expensive than a wholesale license.
Okay with me?
At some point, the intent is that if they're going to get that many brands, they get a wholesale license. That's, I think, what your intent is, right?
We talked about the dollar amounts last time, didn't we? Is there a proposal for the dollar amounts?
None that we were specifically wed to, not wed to at all, actually.
We can talk about it. Do you have any dollar amounts, or
Were you gonna do this by brand or by number of brands or by number of dollars?
By number of brands. So in the draft that we handed out, there are dollar amounts in it. That means Paul's about to speak, is what that sound means.
Go ahead, Paul.
Sorry about that. The original that we had was 1% brand, was only $125, typically for the small startup that we didn't want to chase out of New York. And for 10 to 20 brands, I think we added a 0, made it 1,250 a year. And above 20, we added another 0. On the theory that those folks can now afford to be New York State wholesalers.
Could you do that again, please?
1 to 10 brands, $125.
1 to 10, 125.
10 to 20, $1,250. 20 plus $12,500.
Okay.
So does anyone have any thoughts about those numbers?
Sounds good.
Well,
He did. Hold on, Mr. Cosell.
actually, you seem to distinguish between beer, wine, and spirits. You don't have anything on the beer level that seems to be above 20. I didn't see one. I see that with beer, it just stops at 12.50. The whole concept, and I agree with Kevin, the whole concept is to ensure that someone sells to the wholesale area only and not to the retail area. If you want to engage in retail sales with, good staff and ensure that your brands reach the market, then you want solicitors and you need you need such an expensive license. But why would I get an import license when I can get a wholesale beer license for less? I wouldn't bother. So you got to be careful with the amounts you're listing, because at some point they'll say, well, for that much difference, why even bother? You might as well just chase me out. I would keep the fees much less, and not necessarily I understand 1 to 10, that's the introductory fee, that makes sense. And then once you reach a certain level, they're just selling to the wholesale trade. They're not getting a soliciting staff. They don't want to deal with the retail trade, so why penalize them?
Yeah,
That's number one. Number two is, the other aspect is, why make the fees great enough so that as a wholesale wine licensee, you're spending roughly, $1,500 a year. You've made this license $1,250. Why bother? For the extra $250, you have the full privileges, and why bother with an import license altogether? So if you're going to make the fee structure a little more sense too.
Mark, if I could just interject, we had talked about doing away with the beer importer's license entirely. I don't want to talk for Steve Harris, I don't see him in the room, maybe he's down there, but he mentioned that he had mentioned that there really isn't a need for it in the beer community, but that's neither here nor there at this point.
Well, maybe they're small beer producers like to have somebody in New York to represent their brands, and they want to get it tied into, frankly, to 55C, and maybe they just want somebody to be their importer of record without having to worry about 55C. I don't know, maybe they have something in mind. So they might want somebody like that to represent them. Who knows? Sorry.
I just want to point out that
I also want to point out that if you did it this way, you'd also have to define brand, because a lot of times you have we deal in terms of items on the price postings, and in terms of brands in other places, in the rules of what you can and can't do with a display or gift and services, and neither term is really defined anywhere in the statute. We just got used to them, but now you're going to say, if you have this many brands, so you take an item like Bacardi vodka, right? And there are 15, 20 different flavors of Bacardi vodka. Are those 15 or 20 brands or one brand? I know there are 15 items, but they may not be 15 brands because it's always Bacardi. So now you're into that mess also, and maybe you don't want to have to go there.
So you're suggesting do it by dollar amount?
I'm suggesting that an importer license be restricted as to what you can do with it. And I don't care how many brands you're doing if you have this this importer's license. If you have the importer's license, you price post suppliers' prices, but don't price retail prices. You can't sell to retailers. You're here, and you're selling to other wholesalers. The other wholesalers who have the appropriate license and have paid the appropriate license fees are really the people that are out there selling. And this license allows these companies that want to come into New York and have a presence in New York and have be able to be seen as a New York company, but not really intending ever to sell to retailers and not intending to get into that market, to have that license, have you be able to control what they're doing by being able to take that license away, which is a very important thing to me. But how much the revenue that you're going to get from this is the fact that you're going to suck these people into New York state income taxes. Because as soon as they have a presence here and a license here, they're New York State residents for New York State income tax purposes, and that's where you're going to get your money. These fees are minuscule and meaningless in terms of the overall, state income. And do nothing to advance the idea that was brought forth here that we want to be able to get these people to come into New York and stay in New York.
Well, but the alternate is also if you do want to have an importer's license and the goal is to have a lower fee, then maybe you don't need the graduated structure, but just have it be a lower amount than the full privilege of a wholesaler.
I think that's what he's saying, it's just do one
Right.
fee, make it low, and just
That's right.
limit what they can do.
I don't think it's a bad thing to have a grand definition, but I do think that it's not something that you're going to get done easily at this committee. It has tremendous ramifications to everybody, in terms of much different areas. And if the purpose here is general consensus, it's not an area you're going to have easy general consensus.
Is there at least consensus that a definition is needed?
In many areas, I believe the definition is absolutely needed. I think we need a definition of brand, I think we need a definition of brand. I'll leave it there. There are more places that I think we need definitions, but when you're dealing with consensus, you want to leave those for another day, perhaps.
No, she's just talking in a
Okay.
general sense of the ABC law, which is what he's saying.
There are two basic things that we could do. One is that we could do things that would really make everything better. But we'd all be in the center doing a cage fight. And the other is to get those points where we make things better, but leave open places that need adjustment, but that's not for today, leave it for another day. And I think that's where we are in this.
Oh, you're right. I think, is anyone against making this just simple, one permit, what the wholesaler can do in the state, and make the fee low? Okay.
The,
Get that, Paul?
Yeah, I think I have it. So we'll just do away with the definition of brand in the draft, and do away with the graduation fee structure. And go back to the original concept, which was just limit what you can do with it.
Okay, the next item was the solicitor's permits. And if my notes are correct, we were talking about three different things. One was perhaps eliminating the need for the bond. The second was for the craft manufacturers, meaning the farm licensees and the micro licensees, creating just a blanket permit rather than individual permits for each salesperson. And the third was to extend the duration of the temporary solicitor's permit that's available to the manufacturers for their new hires. So first I'd ask is that consistent with what everybody thought why we were holding it over? And if so, I'll open up the floor or table to discussion.
I like all the ideas.
All three, you think, are? I know there was some discussion, some concern last time about responsibility, for lack of a better term, as far as removing the bond. But I mean, we don't often claim bonds against solicitors. Are there any thoughts about, I mean, those three things, as Mr. Hindi indicated, are we okay with those three items, or some variation?
When it was raised last session, the comment was the reverse, that the bonds have no meaning. In fact, if there's going to be any punishment, the wholesaler has a much larger bond that's out there, and the other one you're going to visit the penalty of bond. The solicitor who has a risk of loss over their permit, and therefore the livelihood, that's more than sufficient to keep them in line. And therefore, the feeling was, why have a bond at all? And the suggestion was to eliminate the bond.
So I take it then everybody's, yeah. Sure.
I have a question on the second one, craft, sort of a house permit for a craft producer or farm producer. And speaking as someone who has like farm distillery, I would rather have the ability to have solicitors represent more than one brand rather than have a house permit that covers all of my employees.
Well, we're allowing that now. After the last summit, the authority, full board issued an advisory that allows for one solicitor to work for multiple manufacturers.
Okay.
Only on the craft level.
Right.
On the craft level, fine.
With the consent of all of those manufacturers.
Okay, sorry.
So that.
Otherwise, I agree with this.
What's the rationale for the distinction explicitly to craft?
Well, at least, it was the craft manufacturers who were coming to the authority saying, look, we're only hiring part-time staff. And, it would open up, more, a bigger field of potential hires if we can hire somebody who's also working for another place, and we don't care if they're working for the other place.
Right.
So.
No, I meant specifically with the solicitor's permit, doing the blanket permit where they have one for all their employees. Is that something that's available?
That was just where the discussion was had at the last meeting. I mean, if the group wants to, talk about expanding it to all manufacturers, then that's what you can all discuss.
We were very opposed to that. It was, I believe it was just for the craft and micro distilleries who were small and needed to do that.
And so, no, I'm just, what's the rationale behind that? That's what I'm trying to suss out.
Yes, you may.
So, there were, did this go off?
You're on hold.
Well, okay. There were two basic issues. One was that the small people were joining together. They're in one little. They're usually in a region. They join together. They hire one solicitor. It has been against the law for a solicitor work for more than one manufacturer, and the reason that that's against the law is because of the conflict of interest that you generally have if I'm trying to sell two different brands. On the other hand, under the craft beer law, in many areas the manufacturer that has this license is allowed to sell other people's products to begin with, which in a normal manufacturer. Not at wholesale, but there's a whole bunch of things about.
Yes, specifically about the blanket permit.
Oh, just to save them money and paperwork. Because
So why not open it up to everybody?
Oh.
Save everybody money and paperwork.
Because the idea was that the solicitor, in bigger companies, the solicitors have to have skin in the game. That's really the problem. If they don't have a license, they have nothing to lose. What happens now is, if you could lose your solicitor's permit because you're breaking the law, you can't work in the marketplace anymore. So now you're out. So now the solicitor has real skin in the game and a reason why he or she has to follow the law. You do with this blanket, they just move from one place to another. You can't take their permit away.
And I'm not trying to take anything away from the craft. I completely understand the exception there. Sorry, let me take that from you. My thought is, though, and I think this goes back to our very first meeting, was that we talked about, a possibility of like trading and having, educating those folks on the laws and what we're holding them to. And I would just say that, I would think that as a large company, we have the resources to give that training and provide that. in a way that maybe others don't. And I think that that comes from, giving them the knowledge to have that on their skin in the game there as well. So as far as a training and education purpose.
Problem with training and education.
Where am I going?
I got it. The problem with relying on training and education, because I give these lectures on training and education, and there isn't a single person that works for any of my clients that hasn't been properly trained. But when you're getting a commission that is based on what you sell, and somebody says to you, if you'll just swipe your credit card, or you'll just do this or do that, the training and the education sometimes takes second place to the desire to make your quotas and meet your numbers. And I think that it is incredibly important to be able to tell all the people that you're training that if they don't follow these rules, they have consequences that are directly to them, not consequences that are to the company, where the company gets fined. Because I trained you, and I can argue that because I gave the training, the fine to the company should be lower. But the problem is, somebody went out there and did this thing contrary to what you trained them. And if they did, there's no consequence to them. Maybe you fire them, but if you fire them, they go work for somebody else.
I mean, I tend to agree with him just on the point that most of the violations I've seen are not due to ignorance.
So they have the knowledge, they have the training, they go out and do it anyway.
One of the other problems I saw was that on the multiple suppliers, that one supplier could be beholden to the problems of another supplier. If they were their permit, they could be involved in something that another supplier did, because it was a multiple. You're not just responsible for one permit. The multiple. Can even remember where it was that a multiple, if you were representing multiple suppliers, that supplier had nothing to do with the problem, could get closed down because of another supplier.
But that's not on the table, though, because the board has done that administratively just for the craft manufacturers. I think we're just looking at now is whether or not the large manufacturers should have a permit for all the solicitors. And it appears that there's not a consensus. Yeah,
right.
all right.
Move forward.
Can I just ask, Tom, if, with respect to the craft beverage producers, there are, as you know, a lot of small wineries that don't, that aren't located on a farm. They're still producing using 100% local fruit, but they just can't get the farm winery license. Would there be a way to include them somehow by having some kind of production threshold?
There's always a way. I mean, we've done that with the.
I don't know that we need legislation for that.
No, it's in the legislation.
Oh,
We've done that with respect. Well, that's not for the temporary permits, but for example, for the temporary beer and wine permits that are available to small wineries, it's done by volume. So you could just kind of borrow that language and put it into a blanket permit that, because wineries are the only ones that don't have the micro version, that if you're essentially operating at a farm winery capacity, you could get a blanket permit.
But there must be
When they passed these laws originally, if I recall correctly, everybody except a farm winery doesn't have to be on a farm, and the farm winery has to be on a farm. Somebody was pushing for that at the time. I don't know who it is, but there's somebody that slipped that into the legislation when the legislation came. So I'm only saying.
I don't think it was slipped in. I think.
I didn't mean it slipped in a negative way. I just.
I think what's happened is
The negative way, the positive way.
is that farm wineries can be on the farm, but the recent
the more recent farm licenses, a decision was made not to have that requirement. It wasn't like we're going to make the farm line be on the farm, and we never gave thought to, because I was involved in the last three farm licenses. And just a decision was made, we're not going to impose that requirement. That's it.
Oh, because you're saying it's because that license came first, the farm.
Yes.
In that case, I have nothing further.
So we could do something like that, all right.
Yeah. By the way, just as an aside, if it doesn't violate any ethics rules, the Long Island Wine Council would be pleased to sponsor the rental of microphones for the next meeting.
How about just bringing some wine instead?
All right, the next item, I think we're all set with that then, right? On those, the next item was the combined manufacturing license for once again, the smaller manufacturers. I think there was a general consensus that this is something that should be allowed, with the understanding that essentially there'd be no change in the license fees. The savings would be essentially paperwork and a filing fee reduction, because you'd only file one application rather than 2 or 3 licenses. I mean, Robert, how many craft manufacturing licenses do you have? Micros?
We have the A1,
Okay.
the farm, and the farm winery.
Okay, so,
But that involved 3 separate applications.
right. So using you as an example, this would replace that with 1 application, 1 document with all those licenses listed on it. So you would save the paperwork and the filing fee, 2 of the filing fees.
It sort of, in some ways, it reflects the federal system, where you can just get a basic permit, and then you apply for the additions.
Anybody have any thoughts on that? Again, limited to just a craft. So if you, for example, if you also had a regular winery license or a regular distillery license, that would still be a separate license you'd have to pursue. Anybody? Okay. The next item was, and I just kind of grouped these as disqualifying convictions. We were talking about the felonies and how you're on your 126, so the people prohibited from having a license. And my recollection is, and I think I included in the email to the members, is that we were talking about 3 different possibilities. One would be that the felony conviction prohibition would just be removed from the statute, and it would just be another factor to consider with respect to character and fitness of the applicant. The second would be to just eliminate those misdemeanors that are still in the statute and keep the felony prohibition. And the third was to modify the prohibition to only go back, I think one example is go back only 5 years, and only felonies within that 5-year period would be disqualifying. Everything else would just be a character and fitness issue. So with that in mind, are there any comments, thoughts, suggestions about any of those proposals? And I think Councilor Flug had some issues too. We had the out-of-state. I'm not sure that this solves any of those issues or not.
If you're removing the felonies from the ABCL, you don't have to be concerned with the certificate of relief for civil disabilities anymore. So it would depend upon what the committee votes.
The problem with just doing option A, which is getting rid of everything and just having a general character and fitness, is you're then going to probably have to do some rulemaking, and there's a ton of litigations, concerning administrative agencies and denying licenses based on character or fitness without having clearly defined what character and fitness is. So I'm not sure, you don't create a new problem with that. I like the third option, where you get rid of all the misdemeanors and all felonies that are more than 5 years old. It's nice and clean. It's across the board. Anything within the 5 years is still disqualifying unless you have a certificate of relief.
Does anybody else have any? Yes, Mr. Hindy.
And my understanding is the prohibition of people with felonies getting licenses goes back to the laws that were made after Prohibition to keep hoods out of the business. Has anything changed in that regard? I would think prohibiting people with felonies would be appropriate. Of course, I'm not an attorney. I don't have clients who may have felonies who want to get into the business. But from my point of view, I think that's appropriate.
On behalf of felons everywhere, which is why I think...
As long as you're not speaking for yourself.
Which is why I think option 3 makes sense, Steve, because a lot of the felonies we see when we're doing applications are really old stuff. People had a tax problem in a different industry 20 years ago, 15 years ago. I think the current movement nationwide, and certainly with this governor in New York State, is to try to get people back into being full-time citizens who had convictions. Often they got caught up with old drug laws and that, So rather than doing a whole list of which felonies we're going to look at and which felonies we don't, I think the third option is a good one, because it's getting rid of all the silly misdemeanors, first of all, and basically saying if it's an old felony, it's old. It's a long time ago, 5 years.
The relief from disability language in the...
And you would still keep the certificate of relief of disability language for a recent felony. So if a person had again, it's often a white collar tax felony. But you can get a certificate of relief, well, then you should be able to, even now if you get a certificate of relief, you could. But I think the third option is not radical, and it doesn't completely change the system, it just modernizes it. And I think it's a good compromise.
And that's the other thing, as Terry just pointed out, we could still deny for character and fitness.
Right.
We'd still be reviewing the old felony.
So if it was something really serious.
This would be automatically disqualified.
Right. We just talked about the automatic disqualification.
A little far afield, but just going back to Steve's point about the history of it, I think it's important that we remember the history is so unique for alcohol beverage because it was after Prohibition. So the idea was that, in theory, everybody already in the alcohol beverage industry were hoods. So it's why, because otherwise you don't see really other consumer packaged goods having as quite tight lock on a history. So I think if we give some breathing space to allow anything that's super old or some of the other options, I think that would be fine.
Did we convince you?
No, but I think
Leaving it to this character and fitness issue is a gray area that I would not want to have to make choices in.
You could call Gary.
Are there hordes of ex-felons looking to start craft breweries? I'm not aware of that.
I think
Actually, there are. I mean, to be fair, there are many people who have in their youth been caught up in felonies who now, it's 10 years ago, 5 years ago, and they want to get into an industry. They want to open up a restaurant. They want to open up a package store. It's not just breweries, or they want to open up a brewery, and they are foreclosed. So the answer to your question is yeah, a lot.
It's not only just felonies though either. There's a lot of misdemeanor convictions that they are allowed to file for the application, but when we look at it, we take them all into consideration together, and they're worse than the one felony that somebody might have been convicted of.
This would not take away their powers to really still prohibit really bad people, because they still would have that. They could still require any felony to be disclosed.
So I'll never get a license.
You're out. But for the average old irrelevant felony, you don't have to jump through as many hoops with an application.
This was also brought up
with the solicitor permits and the inability or the time frame it takes to get releases from out of state, that sometimes the 6-month temporary permit will expire way before we can get a release, or if ever get a release from out of state for solicitors. So it's not just on a full licensee for a retail store or a wholesale license. It affects sort of the ground level people that kind of need a new break. And if it's a 5-year-old conviction or even older, it was the idea of forgiveness and trying to incorporate them and bring them to the trade.
And last but not least, Steve, that the older the felony, especially in another state, the harder it is to get documentation from a lawyer, whose practice is retired, and I've lived in that state for 15 years. It really holds up applications a lot sometimes. Even though at the end of the day, once we get them the documentation, they have no problem with it, but they can't do it without the documentation.
Five matches the
It matches the federal law?
I think it was brought up last time that you got to be a little careful with this passing legislative muster, but I think the 5 years sounds like a reasonable approach.
All right, then, move on to the next item.
The next item was wine growlers, and if my notes are correct, I believe the discussion was headed toward the farm wineries and allowing them to have the same, actually, so the wine to go, the bottles of wine to go, to let them do it as long as they have the food requirement that is required now of the restaurants. You know, they have to have food available to take the bottle with them. That was my recollection. The discussion was headed, was that we weren't going to go any further than that, but there was some discussion about letting the farm wineries sell bottles, farm wineries to sell, allow the bottles to be open at the location, then taken away, half filled.
No, that's not a growler. We're talking about growler.
Right, but the discussion was kind of combined, okay?
So the discussion as far as growlers and liquor stores off the table.
My recollection was that was the package, nobody was looking for that.
Okay.
So we were focusing primarily on the ability of the manufacturer, the farm winery, to be able to sell a bottle of wine that's opened up on the premises and then taken away. And also the wine growlers. I'm kind of combining both items. But there was a concern about the food, and that the food requirement should be that's in 81 that we talked about before, should be included with that. So I'm just wondering, is there any more conversation about that?
Are you saying that the food requirement would require the farm winery to offer food, or that the person has to eat it there or take it with them? What is how does that affect?
Offer.
So they would need availability to food?
Yes.
Okay.
Well, I mean, that'd be a question for, right now for the restaurant wine licenses, to sell that bottle of wine and it'll be taken away, you have to have a meal with it. It's not just availability of a meal, there has to be a meal.
I don't get this at all. It doesn't make sense to me in both directions. Farm wineries can sell wine to go to begin with. So the issue here is, should they be able to sell wine to go in a growler? And I don't see any reason why they shouldn't be able to sell wine to go in a growler.
The bottle's already open.
Or if the bottle's already open. I mean, I don't care about either. They can sell wine to go to begin with. This is a different concept than the concept of restaurants, which, I go to a farm winery. I'm at the farm winery. I don't know I don't picture in my head, because anytime I went to a farm winery, I would taste the wine that they offered me, and then I would buy the bottle. I wouldn't open the bottle and take it to go, except if I was eating it in a restaurant, like any other restaurant. But if they wanted to have growlers, let them have growlers. On the other side of the coin, you're talking about, okay, we have a situation in which on-premise licensees are not allowed to sell wine to go. There was a concern that if people bought a second bottle of wine, either they would get drunk because they'd have to they figure, I pay for it, I have to finish it, and I get drunk and drive. That's bad for everybody. Or I don't buy the second bottle of wine even though I want it because I'm afraid I won't be able to finish it, so that's bad for the restaurant. So we came up with a law that said, okay, if you're having a sit-down meal with a knife and fork, utensils, right? And you have a bottle of wine and you haven't finished it, they can put it in a bag, cork it, they can cork it, put it in a bag, mark it, put the receipt in it, and under those circumstances, only they can sell it to go. There's no reason to bring these two things together. They're completely separate, right? If you want to talk about, the way you should do this, if you pardon me, is farm wineries can sell growlers. If they have a restaurant license and somebody bought a bottle, the restaurant, they have the right to sell the bottle that's been opened to go only if it was a sat-down meal with the restaurant under their restaurant license. They want to sell a growler, they sell the growler, they sell the growler, they can sell the growler on any side. They want to do tastings, they can do tastings. Don't mix these things together, they're completely different.
It's just that there are situations where people do come in, sit out on the patio, and purchase a bottle of wine, but they don't finish it, and they want to be able to take it with them. And so I've had the question many times, can we sell the bottle, cork it, package it the same way a restaurant can, and let them leave with it?
I got to tell you, honestly, when it comes to farm wineries, I don't care. So, you know, whatever.
At the end of the day, when it comes to farm wineries, I don't care because it's a small, localized issue, and it doesn't really flow into these other things. But it shouldn't be. We shouldn't run this into restaurants. It's a completely different thing.
We're not talking about.
But I think the point was made, I think last meeting, is that there should be some kind of food requirement and offer food requirement, which there is right now in a winery license. To be able to serve for consumption on premises, they have to be able to offer some type of food, and we would have no objection to that, if offer.
As retailers, we don't really want to sell growlers, so farm wineries, God bless you with growlers. The governor has made a big push for us as package stores to sell local New York product, and we are all doing that. So for the ability to sit at a farm winery, open a bottle of wine, drink a few glasses and cork it, could prevent that person from coming into my store and buying it. So with that in mind, we would prefer that the food requirements stay consistent for all farm wineries, so that it's just, and restaurants. So it's clean, it's simple, it's easy, and it's consistent.
Hello, this is Buffalo.
Food requirement exists for the. Somebody in Buffalo. Go ahead.
Hi, my name's Ted Marks from Atwater Vineyards on Seneca Lake. I'm a farm winery. There is no way that I can serve food, and I don't know hardly any farm wineries that have the ability to serve food. We want to sell growlers, but the two of them, again, I agree with the gentleman that said you're mixing up two different items. I have breweries all around me, they sell growlers. Why can't wineries sell growlers?
I think we're agreed that that's.
I think we're agreed that that's, there's a consensus to allow that. I think where we're focusing on now is the issue of the bottle of wine purchased at the premises to drink there and then leaving with it when it's not finished, which is what the restaurant wine licensees can do.
There are very few of us that would sell a bottle of wine to somebody to then walk out the door with an open bottle. We don't do that. We want to sell a full bottle. People don't just come into a farm winery is sit down and pour themselves glasses. We don't have those type of facilities, really.
I think Mr. Bate would suggest that there are places, at least in Long Island and perhaps the Hudson Valley, that are doing that. And Mr. Edwards is pointing out that's maybe an issue with the retailers.
The offer is on the table.
The food requirement exists for farm distilleries. I don't see any reason, and it's written in a way that allows us to easily make food available, ham snacks, things like that, crudité, that don't need service. And it works out very well. And we have no complaints about it. I think the same approach could be taken to this requirement, to the food requirement for farm wineries. So you would not have to have waiters and waitresses, and you would not have to have dishes and forks and knives. In fact, I think that the statute says it can be eaten by hand, things that are eaten by hand. So I think that would solve that problem.
And it wouldn't relate to the growlers. The growlers would be irrelevant.
Separate issue entirely.
Growlers, you wouldn't have to have any food.
Right, and I know from our point of view, we wouldn't want to, if somebody came in for a sample, wanted to buy a bottle, we wouldn't open a fresh bottle, give them a sample, and then sell them that bottle. We'd give them a sample off of our stock of samples, and if they wanted a bottle, we'd give them a brand new bottle. So I don't think that that's going to be a problem. I mean, we don't want them walking out with half-empty bottles and open bottles, because when they're driving home with an open bottle, they're in violation of the law.
So I'm not sure where the group stands right now on this. Doesn't seem to be there.
Well, I think there's a consensus on allowing
But not on the other issue.
Not on the other.
Right. Now, of course, as I think somebody pointed out, if the farm winery has a restaurant wine license, or if the farm distiller has a restaurant wine license, then those provisions apply. Okay.
Why isn't there a consensus on consensus about whether or not there should be a food requirement?
Well, I think Mr. Edwards goes a little further than that. You just, correct me if I'm wrong, I think you're just opposed to the general idea about whether there's a food requirement or not.
I'd like to, it's okay as long as there is a food requirement.
Oh, there is, okay. Oh, all right, okay, I'm sorry. All right. The next one on my list was the wine products. And I believe we left this off with trying to think about whether or not there's some other name to call these things. Make-believe wine or whatever. So I'm not sure if anybody in the month that since we met last week, anybody's come up with a really good name to call these things. Or does anybody have any suggestion about what we should?
Mr. Bookman, yes.
Is there some thought about where to go with this, or if we should go any place with it?
My last suggestion was that whatever it's called, it not begin with the word wine, because as soon as the consumer sees wine, then that's what it is. So there were some things on the table like faux wine or byproduct wine, something that disqualifies it as wine.
I was just reminded I was supposed to come up with some ideas and I totally forgot. I only have an interest in it as a consumer, and I'm sorry.
Mr. Chairman, we go through the consumer protection law. What words are generally used with products to indicate that it's not the actual?
The problem here is there is actually wine in this.
Can there be a definition based on alcohol?
It is
Most of
really-
these low alcohol?
Yeah.
It really is.
So low alcohol wine product.
Definition is, well, that's different, because a wine product is wine with other things added to it, and a cap on the alcohol content. Whereas there is low alcohol wine, which is separate.
What are wine coolers? Is there a definition for wine coolers? That's a wine product, so what if they were called wine coolers?
Go ahead.
I think it's going to be hard to get wine out of it as much as you might want to, but if it was a wine product, could be a wine, but a wine cooler would definitely be carbonation and would be different.
Well, carbonation is required now in a wine
Yes.
product.
No, what he's saying is that New York calls it wine products, everybody else calls it a wine cooler.
So why don't we call it carbonated wine product? Why don't we call it carbonated wine product then? I didn't realize they were all carbonated.
It has to have CO2 in it.
It's part of the definition, but I have to say, just so that everybody understands, there is no wine, none, that doesn't have CO2 in it. So when it comes, and there's nothing in the statute that says how much CO2 it has to have. And a lot of the wine products that are out in the market today have trace CO2. So, and I don't care what you do here, but just so you understand, if you say carbonated wine products, you're actually going to, in many cases, create consumer confusion rather than do away with it, because most of the wine products that are sold in New York, you won't taste the carbon.
I think wine cooler works.
Yes.
Can you pass that down to Mr. Weber?
Trying to get you there.
I won't fall out of my chair, but I may walk down and take it. So I have a question, because the consumer issue, the deception of the consumer, how does anything we do here in terms of changing the state law affect the labeling and the ability of the consumer, because at the end of the day, it's about the consumer seeing what looks like a wine bottle with a flavor that is called a flavor we associate with wine. And if that's the core issue, I think the question is, what can we do here to get at that? And if nothing, then we probably should move on. Because you can call it whatever you want to call it, but if it says Chardonnay in the bottle, we still haven't solved the problem.
That I think we've all concluded we can't do anything about. Is it possible to address it by simply addressing the size of type? Because we saw bottle label examples where the wine was the largest thing on the label, and underneath there was a little thing that said product. And if you required them the same size type, we can vary from, in the same neighborhood, we can vary from the TTB requirements.
There is no CTV requirements for wine.
No, I understand.
They're not wine for TTB purposes.
Right, okay. So, but the point is that that can be a control point, is just specifying the sizes of the types on the label.
I think that Chairman's comment about himself being fooled by the product, thinking that wine was in grocery stores, is the core of the problem. That's the root of what we're trying to get to. So I think we talked a lot of different things, and not any one thing was the solution. One idea was to say it can't be bottled in a wine bottle. It has to be bottled in something else, or perhaps a can.
But I don't know that we can do that, because I think that's a federal issue, correct?
I thought you had labeling and packaging approval.
You have labeling authority now. We wouldn't have to change any law to change the labeling authority. With regard to bottling, you could pass a statute that said in New York, wine products have to be in a certain kind of bottle. But I personally don't see it. I mean, you could do it. It's not like the state of New York doesn't have the authority to say, you want to sell a product in New York, this is what you have to, what it has to be. The real problem is that, just so everybody understands, because there's no definition of how much carbonation has to be in a wine product, and because of the other things that have to be in a wine product. I mean, to make a wine product, you need carbonation, you need wine, you need fruit juice, and fruit flavoring. I mean, I think that's pretty much it. And if you think about the definition of wine, most wines are that, because most wines, they add something in the finishing of the wine, additional fruit juice to change the, especially. And I'm sorry, and the alcoholic content has to be, there's a low threshold of alcohol content, which brings it below the TTB definition of wine. So that's why we get labeled, that you get New York State label approval and you don't get federal COLA label approval. Because while it's an alcoholic beverage for federal purposes, it's not wine. So you could change the definitions, you could change the names, but as it stands, somebody makes what is essentially a low-alcohol wine, it has carbonation in it, it fits the definition because they lower the alcohol content by adding fruit juice, and at the end of the day, if the grapes that it comes from are Chardonnay grapes, saying that they can't call it Chardonnay is just saying you can't give information to a consumer, and there are some federal freedom of speech rules that say that limitations of language that only conveys accurate information is not allowed. It's a violation of the First Amendment. So I think you want to change what you call it and say that, or you want to administratively say, I want the word wine product to be, very large on the label. That's something you don't need to change the statute for.
He said the bottle.
I don't think that that's a practical solution to tell people how they have to put this product in a can, but you could pass that law.
While we were sitting here, I went on the thesaurus and just looked up the word fake and came up with imitation, counterfeit, fictitious, make-believe, mock. I mean, any of those adjectives in front of the word wine and in front of the varietal, I think can be, and if I had my magic wand, and put it in a different bottle. But something that's in front of the word wine that lets the consumer know that it's not wine.
I don't think you can do any of those things. And plus, what do you want to disparage a product for? It's a proper product. You have all the wineries. You have New York wineries producing this stuff. That's not what you want to do. If anything, the most you could do is possibly add a decal or some kind of information that makes it clear to the consumer just what it is they're consuming. It's the best you can do. You want to protect maybe consumers because it is a wine. It is a wine specialty. It's not a fake wine. It's not an imitation wine. Those are incorrect terms. It is wine. You don't like it, but that's what it is. If you want to make it, then the state has, in its wisdom, has decided or determined that this kind of product can be sold in grocery stores. But it's an FDA label. The consumer takes the time to look at these labels. They will see that there are differences. There's supposed to be an ingredient list. It has to comport with FDA labeling requirements, not TTB labeling requirements. You have to have a list of the ingredients. Much different than it would be for regular wine. The consumer would understand that, educate them, that's fine. Short of that, the best the SLA should do would be maybe a decal or a sticker that says wine product, and make sure that that is there and very clear so the consumer knows what it is. They won't see it on a line item because they don't have to do it. Most manufacturers don't want extra indicia on their labels. They want them clean. They want the consumer to see them. Anything that creates an aberration will stick out. That's the best you can do.
It's not that I just don't like it. It's that we all had agreed on several of these meetings that it was misleading to the public. That much we had agreed. So now what we're trying to do is make it clearer to the public in many different ways, or whichever ways are legal.
I think there are a lot of people that are buying it where they think they're getting Chardonnay or Cabernet, and they're not. And the whole issue started when the wine coolers came on the market. The state, it was a new category, the state didn't know what to do with it, so they created this wine product thing to straighten out. It was supposed to be all New York State grapes originally. That was unconstitutional. And that's what started this whole category. And with any new category, there's always abuses. And these people are taking advantage of it and making the consumer think they're getting Chardonnay, Cabernet, and real wine when they're not. Now, it's a legitimate business, but I think it's got to be, the consumer's got to know what they're buying.
What about as a compromise, putting the word wine in quotes? So it might start the conversation if you're in the store, you might ask the supermarket, why is this wine in quotes? And then the supermarket say, well, it's not real wine. I don't know, something as a, maybe without completely altering the label.
What if you put the definition of wine products on the label?
How much room do you have on the label?
Tom, I'm just going to respond to some of the language that came across.
across, I mean, working really heavily with our brand teams in-house, anything like that would just be met with significant opposition. I think to a consumer as well, I hear your point, I hear what you're trying to understand, what you're trying to accomplish. I think there needs to be a balance between maybe disparaging the product, which I think some of those words have a really negative connotation, and educating the consumer. And if there's a balance that can be struck there.
Well, what about the sticker that Mr. Kozlow mentioned? That doesn't seem like a bad idea.
Seal versus
Seal,
sticker.
One of my colleagues suggests the word flavored in front of the word wine.
That's not bad either.
I don't think the word imitation is disparaging.
I do.
That's the problem,
I do.
is it's not imitation.
In front of their product. David,
Right.
how many products do you sell as a wholesaler have the word flavor, the word imitation in front of it? Zero.
Right.
Thank you.
Flavored.
Right.
Does anybody even test this stuff to know if, when they call it Chardonnay, that there's actually any Chardonnay grapes in there, or is it just a white wine product?
I'm pretty sure.
You're welcome to. I don't think I'm gonna get that kind of money.
You're gonna get that kind of money. One of these wine guys should do that. I mean, because then you have a clear consumer fraud case against them. If they're calling it Chardonnay, and there's no Chardonnay in it, it's just some white grape.
It's not.
Well, and there's plenty of that going on in the alcohol industry.
What about flavoring?
I think the decal would also avoid language barriers. A little decal where universally understood that it is a flavored or an imitation, which doesn't, disparage it by name, everybody could see, like kosher, everybody sees the little page, it's kosher, maybe a little decal on the side, everybody universally would understand.
Well, we can do that, right? That's part of the labeling, right?
Well, we have the authority to regulate products or labels that are deceiving to consumers.
I know. Not imitation, no. That's, I don't mean to say imitation.
Is this, and I think the discussion is fantastic, is there a way, and I think I'd emailed you, Tom, on this one, is there a way that we could see some proposed language from somebody, or, if there's a person that's going to get, and then
That's kind of why
circulate
we
it?
held it over to see if anybody had
proposed
but
language.
Rob didn't do his homework. So.
I thought of invitation. I thought of that one.
But you can't call it imitation, it's not imitation. It's not phony, it's not fake, it's not imitation.
It is flavored, though.
So,
It is flavored.
as representing grocery stores, we're the ones that sell this. I think originally someone brought up that there was a big sign in an aisle that said wine. Now, but then it was clearly said that's misleading. Straight wine, if you just put wine without wine product, that would possibly be misleading. Well, I think what I'd like to do is maybe go back. I talked to our guys, and they didn't have really an issue with trying to come up with something different. Most of them, quite frankly, they don't want to mislead the consumers. They don't want to have a consumer buy what they think is wine and then come back and want to return something that has a glass poured out of it and say this isn't wine at all. So they want to.
Did they indicate that does happen a lot?
That wasn't indicated, but I'm sure it does. So they don't, again, they don't want to mislead people, but maybe if I get another opportunity here to, I'll survey some of our members, or so we'll try to brainstorm and maybe come up with some sort of term.
It's also the pharmacies and the convenience stores that are doing it.
Put a sign with the
That's alcohol level that it has to be below to
Can I make a suggestion?
He actually has a good idea.
Supposing you pass either a law or a regulation, that says that wherever this product is sold, whether it's sold in a package store or it's sold in a supermarket, that there has to be a sign near where it's sold that explains what a wine product is.
Point of display.
A point in the rack, near the rack, it says a wine product is, and it says under New York, this is a wine product. Under New York law, a wine product is, and here's the definition of wine product.
Alcohol, whatever.
And then you have everybody who's buying it knows what they're buying, and they know what they're buying it right there where they're buying it. And if they buy in the package store's got to do it. If they buy it in a supermarket, the supermarket's got to do it.
Is that done on anything else that you're aware of?
No.
Let's see, supermarkets.
You have to put prices near things, and that's in our statute.
And also if you're selling, I believe in supermarkets and ag and market. Ag and markets, I think, has some things like that for fruit and vegetables that come from other countries. It has to be a sign that says, please note that we sell products like,
The pregnancy test.
you
have 5 signs that you have to put up with the sale, just to sell.
And just think, what you grab for sign violations is a whole new source of revenue for you guys.
You put in the statute, you put in the statute. But it's better than telling people that something that
You could have a point of display sign that says, please note, the wine products in this area are low alcohol, do not meet the legal definition of full wine, one or two lines.
Saying what is, here's the definition of wine product, this is what it is.
That's correct. Well, the retail has responsibility on that, to mislead the consumer. Supermarkets get violations for a box of Kellogg's cornflakes being short weight. What did they do except took it out of a carton and put it on the shelves? They're definitely responsible.
Well, I'd like the opportunity, if we do move forward with this sign idea, to just discuss some ways.
Why don't we do this? And Tom will put it in the report, draft it, and then when we meet again, we'll come to a final conclusion about what it is, and we can put both of those options.
I was just going to say that not in New York, obviously, but in California, there has been a retail sign program that related to Prop 65. It was all the manufacturers got together and were able to work through that. And there was a sign posting program, and they had some sort of efficient system that got the notices out to all the retail licensees and required them to post them at retail. So, California legislation that basically says certain ingredients in your product could cause cancer, and you have to put a warning out there. So there was a requirement that warning could have had to be on all alcohol products. So in order to get around that, they hung up a sign at all retail locations. So, yeah.
I just want to express the thought that it will be very difficult to get through the New York State Legislature a bill that requires some 30,000 retailers to put up a sign in order for those wineries to sell the wine products that are supposed to go into the production of those products. This is much better dealt with within the regulatory authority of the SOA to do something with consensus of the industry than put this in a bill that will likely end up turning it into a discussion about why retailers are being held responsible for the actions of manufacturers and wholesalers.
I told Kevin that's the problem with this. Because they're selling it. They're the point of sale, and they're selling it, and, if there was,
They'll threaten to stop selling it, and the wineries will.
I understand what he's saying.
Yeah, I understand too. I don't know the solution.
I didn't object. I didn't object.
No, I hear what you're saying.
I have to say that I think there's a mistake to put the onus on the store owner. I think that it's the responsibility of the producer not to make sure that the public is not misled by anything on its label. And if the only thing someone sees when they look at the label is Chardonnay and wine, and it's not clear to them that it's neither of those things, then it's the producer's job. And in law, it's very clear that they cannot mislead the public.
I think you're right, but I don't think you're right when you say it's not Chardonnay.
Well, it's a wine product, excuse me. But the point being that it is the responsibility of the producer and bottler to make sure his label is accurate and reflective of what's in the bottle.
We just ended.
Yeah, I think.
If
you call it Chardonnay Light, it'll up the sales. Oh, it's a light product.
That's why we should have a conversation.
People into thinking that they'll lose weight.
Yeah.
and correct me if I'm wrong, but I think we've kind of reached an impasse as far as not if there's a problem, but how to address the problem. And perhaps we should take up Mr. Wexler's suggestion and, after outside of this group, look to see if the authority can do anything within its regulatory power to address it, or what else can be done. But unless somebody has anything else, I don't know I don't see a consensus here among the group members as far as what should be done. I think everybody agrees that there is an issue to be addressed, but not how to solve it.
And I would add that I certainly wouldn't object if we included something in the report that addressed where we have consensus.
Okay.
That there's a
consumer issue
to be addressed. And perhaps, I mean, we are time constrained by our meeting schedule, but the legislative session will go on. Maybe there is a statutory provision. Maybe you'll find something through your regulatory administration. I don't want to diss the idea, but I also want to honor the lack of consensus.
But if you point it out as a problem, you may have people solving the problem that you don't want solving it.
Okay, so we'll move on to the next item.
Maybe time for a 5-minute break?
Sure. We can take 5 minutes.
Another good idea of us to, okay.
Available for $25 a chair?
Scott, you have to be convicted of a felony. If everybody can please take their seat. We're going to get started now. Mr. Bookman's outside on his iPhone, so. Anyway, the next item was the marketing permit. And we had held it over, it was whether or not the provisions of the marketing permit should be incorporated into the various license privileges, not to eliminate the existing marketing permit, which gives wholesalers and importers and so forth those privileges, but with respect to our craft manufacturers, to specifically put that permit or those privileges into their license. I did send the members of the group language from the Farm Brewery Law, which contains a watered down marketing permit just with respect to tastings. So what's up for discussion is whether or not there should be some language similar to that, but including not only tastings but bottle sales for off-site activities for the manufacturers, and to eliminate their need to have a marketing permit. I think one or two people had concerns about that. Yes, Mark?
You had raised a concern, which I agree with, which simply was that you change this term multiple times. You make it statutory, you won't be able to do it. And so you're better off just leaving it all alone, and that the marketing permit.
As it stands now, is very valuable. It's flexible. If it needs to be changed, it can be changed, rather than make it statutory. That was the comment.
The only, and I don't know if the only thing I would say is that the changes that not with respect to adding privileges for
what I would say is that the changes that have been made to the marketing permit, I think have less to do with adding privileges for the manufacturers, but adding other entities into the mix. We added the importers, we added the foreign manufacturers, we added the trade associations. I understand your concern, I just toss that out there.
Hello?
I think you reached your maximum.
Hello? Yeah. Said all I was supposed to say here.
You got to put $5 more into it.
Yeah, I actually am against this because this is working so well. There has been no problem with it. I don't see any reason to change the statute, and I get afraid that you try to change the statute, all of a sudden everybody starts coming in and saying things, then judges come in and say, well, when they brought this up, statutorily, this was left out, this was put in, and they start reading into something that's working perfectly well and is within the discretion of the authority under the current permit laws. And there's nobody who can't get it, and there's no.
What about the concern raised, at least by one person, a legislative staffer, that the authority never had the power to issue the permit to begin with? And that, let's say, a new chairman comes in 10 years. 10 years, all right? 6 months. And says, and convinces the other members of the full board, we're going to abolish the marketing permit, so that is gone.
I think that the likelihood of that happening is, to me, the likelihood of that happening is more remote than the likelihood that once you start having the legislature muck around in this, that they will cause trouble that we will not be able to do anything about. When a permit has been issued and it's been around, now it's been around for probably 4 or 5 years, I sincerely doubt that anybody is going to come in and say, here's something that we've been doing for all this time, that the entire industry is behind and likes and uses and is going to come in and take it away. I don't think we need the statute. And by the way, the statute authority, notwithstanding whatever staff of that was, the statute authority is in the permit section, which gives an open end to any permits that the authority thinks necessary and not inconsistent with the rest of the statute.
Let me ask Steve and Ralph, who represent more of the craft manufacturers, and Paul, are you comfortable with the current arrangement?
Having to apply for the marketing permit and then renew it every year is a pain in the neck. Every 3 years is a pain in the neck, but it's not onerous. And we have no problem with it and never have. Once we understood the limitations of the marketing permit and the permissions that it involved, we're fine with applying for it, and the renewal is no big deal.
We do have manufacturers who have objected, however, so I don't know if it's just limited to manufacturers.
I mean, I agree totally that it's working very well right now, but we have a lot of my members who have objected to the fact that they have to apply for something that's basically almost pro forma that they're going to get it, so why not include it in their licenses as of right? And I have the previous version of a craft beverage proposal from last year, which has it very nicely laid out as to how it could work. So again, I agree with Ralph. It's not a huge problem, although it is, it's an additional layer of bureaucracy that we have to deal with.
A small operator, very small operators, many of them who have maybe 2 staff members,
The owner and his wife, for them, it is a burden. But for any of the mature operations that have an office staff, it's really just another application every year, every 3 years to renew.
But I tend to agree, but as I hate to say this, I tend to agree with Mr. Dano. If you get the legislature mucking around in something that's working, you never know what you're going to come up with. So that's just my 2 cents.
I agree with Ralph's comments, but I think Paul can speak for some of the smaller producers.
Well, I mean, the smaller producers would certainly like a reduction of fees, and they would like automatic renewal if they could, and make it much easier. That's pretty much what I'm hearing.
But taking into consideration Mr. Daniel's comments, can you live with the way things are now?
Yes.
Okay. So I'll take that as we don't need to address that in the report, but perhaps there's something we can do administratively to make your lives easier.
Through the current marketing permit, I also, a lot of brewers would like to expanded privileges to farm brewers to be able to sell have expanded privileges to sell by the glass or by the bottle.
But they can get that through the other temporary beer and wine permit, though.
At farmers markets, for farmers markets.
Mm-hmm. Okay, so then the next item then is Mr. Bookman's issue, the 106 subdivision 9. I sent, to those of you in the group, I sent you the particular language from section 106 about the access between the on-premises licensees, unlicensors, and so forth. So maybe, Rob, I'll turn to you to kind of get the ball rolling.
And the speaker's off. In typical ABC law fashion, the section which was sent to us starts off with no restaurant and no premises, and then you reach further in the paragraph and it exempts restaurants. So. Right. So, I mean, it's confusing in the best of circumstances. Where this problem arises is typically in a hotel, for example, where the hotel may have a license, may have a lobby bar, and they have a tenant, let's say, that has a top floor, a rooftop lounge. It's not part of the hotel license; it's a separate entity. Technically, if you read this section of the law, liquor authority can't license that rooftop unless they have a separate entrance and a separate elevator, and it's really kind of silly. And I think for decades after Prohibition, this was really designed to deal with speakeasies that were literally underground and behind doors, and you had to knock on, a door, to get in. So the post-Prohibition law wanted every place, specifically bars, to have, a public corridor, if you will, to get there. It's kind of lost its, it's kind of lost its meaning over the decades. The liquor authority has had to come up with definitions for malls, for example, that, okay, we're going to consider all the hallways in the malls public areas. And so there's a lot of contorting going on to try to get around this ancient statute, which I don't think anybody really cares about anymore. So, I mean, we could live with it forever because we're all working our way around it, but as long as we're cleaning up the law, it seems like a good thing to clean up, that it should not be a violation to have to walk through another portion of a building to get to a licensed premises.
There is. First, let me say I have no objection to this, so I don't want to give the impression that I do, especially if Mr. Buckman wants it. Why should I get in his way? But there is an issue that was addressed by this statute that perhaps you should consider, and that is that when you go through one premise to get to another, the hotel premise to get to the rooftop bar, you have the issue of whether or not the person who controls premise A can stop, for instance, the SLA from getting through her premises to get to the premise that has the license, because now you're talking about there's no public entrance and there is no access except with permission by somebody else. And it's just something that you should consider, because if you theoretically put a tavern in the back of my house, when you came, when I was serving the minors, I just say you can't come in. And what do you do about that?
You could require, they could require in situations like that, that the lease that we provide as part of the application makes it clear from the landlord that public access, shall not be restricted and shall be provided.
And that works.
And that works.
Anybody else? Does the community board have any? There's a microphone right there.
Really not at this time we have an opinion on this one, but it would be good to be sent it to the community board to be fleshed out. As a matter of fact, we have on the agenda for next week 2 applications in a building that was a store before, and now we have 2 applications for 2 different applicants for the same building, and it was cut. It's on the agenda. We're going to be fleshed out next week, but this type of item, I don't know. I can tell you right now, it should be fleshed out at the community board level.
Well,
Mr. Smith, are you talking about the idea in general or specific applications? Because the applications would still go to you.
Well, I have a case with a specific application at this time, 2 different applications for the same premises. But right now, what you're proposing here, I can't speak on behalf of the community board what they're feeling that, because with the changes that we have in the district now with gentrification, many big places put it down in the small places, we don't know what can happen,
If you could, maybe between now and the next meeting, kind of get us some information so that we can incorporate that into the report, and so for everybody to consider when we take a look at that then.
But the process of community board has to be discussed at the committee, then presented to the full board. I'm going to bring this to the executive committee next week, and let's see what can happen.
Thank you.
I just want to be clear. This has nothing to do with how many licensees can be in a particular building. This has no impact on that. The Time Warner Center has probably 12, 15 licensees. As warehouses get converted, there may be multiple applications. Those applications will still go before your community board each month, and you'll still have the 500-foot law, etc. This is just talking about passageways, basically.
It's stuff that we're getting around already, but we're jumping through hoops to do it.
Right.
This affects the restriction on having a tasting room next to another business where there's some kind of a passageway through, for example, a convenience store, a tasting room, sharing a building.
This is specific to the on-premises licensees. So.
Still a tasting room.
A tasting room for who? For a
winery.
Well, that's part of your licensed premises, so.
Yeah. That's all part of your license.
Right now, there has to be,
Are you talking about the branch offices?
no, not necessarily. It could be a branch office. So needs to be a separation between
Yeah, it doesn't affect
a
that.
non-licensee and the licensee.
No, it wouldn't affect that, no, because your licensed manufacturing premises still has to be separate from any other businesses. The next item is the Sunday hours of sale. I have 2 points. One is that there's been a bill introduced by Senator Morelli and Senator O'Mara that would create a permit system, annual permits and one-day permits to open up early on Sundays. That was just introduced the beginning of this legislative session. And the other item is I have a personal interest now in this matter because the Giants lost to the Eagles. They have to go to London next year and play against the Rams. All right, so.
You're recusing yourself from this discussion?
No, I will be supporting, okay, at least for that one day, earlier on hours on Sundays.
Maybe they can win a game next year if they got to go to the
What is the purpose of
This is with respect to the Sunday hours for on-premises licensees.
What happened was this year you had the Giant game was on a Sunday morning before. Bills game was on a Sunday morning before you were allowed to open up. And all of the fans who want to go to bars and have a beer while they watch the game were angry. And the liquor authority could do nothing about it because it's statutory.
And there are other sports, I mean, soccer, for example. Soccer is often Sunday mornings. And Mr. Edwards, I'll have to defer to you. I don't think we were pursuing early hours for package stores on Sundays. No, this is just limited to on-premises hours, right? Mr. Smith, yes.
We would like to know if it's possible that this bill be sent to the community boards so we can study that, and if it is approved by the legislation in the state, the permit application can be going to be part of the process going to the community board.
The bill.
Yes.
Does have a requirement for community board vote.
It's a bill that's already been introduced.
It's not our bill.
It's okay, but because it has to be case by case, and what is the legislation is asking for application for a particular establishment is good idea, because we can have bar operators in the district that going to start the problem early on Sundays, and the community board has something to say on those type of application.
Yes, thank you. Sunday morning sales and compliance has been a big issue in the on-premise industry for years. As Tom mentioned, we have a variety of sports. I get calls from soccer or football bars, English football bars all the time about this. And I also get complaints about licensed premises that are open in violation of the law. I appreciate Mr. Smith's appreciation of the issue the way Tom explained it. The idea for Sunday morning sales has been advanced before in a variety of different ways, but I would recommend this group, if we're going to consider endorsing something, look at the proposal that legislators Morelli and O'Mara have introduced. But it's not a blanket authorization, it's a permit, and it's a case-by-case basis. And if I understand it correctly, it parrots, it follows, provides the localities, community boards, and outside of New York City, the local municipality, with the same input into the decision to grant the permit as they do have in licensing. And also, it gives the authority the ability to pull the Sunday morning permit should the licensed premises do something that would make you want to pull their Sunday morning operating hours because they didn't, but not their full license privileges. I think I understand that the legislators Morelli and O'Mara have been working on this idea for almost a year, so it's a very reasoned and well thought out piece of legislation, and I would hope we could endorse it.
Do you know that if this permit, that you have to apply for the permit, and I'll have to read it, but you have to apply for it for every, if a...
There's two permits. There is an annual permit.
Okay.
There's also a single event permit.
Well, the big annual permit, I have a Sunday morning brunch, I have a sidewalk cafe that allows me to open earlier on Sunday. I want to be able to serve alcohol, during that period of time.
Yes.
And in Buffalo, would have been the bill.
And I believe, I have to go back and look at it, I believe the language restricts what types of on-premises establishments. I'll send a copy of the bill to everybody so you can look at it. Oh, yeah, it's filed, the bill is, this is not a proposal by the authority, this is a bill that's been introduced in both houses.
Okay, so we'll send you a copy of it, and we'll write it up as if, well, Tom will write something up, but we obviously will change it at the next meeting, because you'll all have a copy of the bill by then.
I would be remiss if I didn't say the following. Why is Sunday morning different than any other morning?
Thank you.
Well, there's only one possible answer, because it's a religious holiday for some people in the state of New York, but not for all of us. And if we're going to be a multi-ethnic, multi-religious culture, I think we need to respect everybody's culture. And being a minority religious person is offensive to me for state laws to continue to recognize one religion over another. And I don't see the reasons there should be any statutory restrictions on Sunday morning hours. As far as the community board is concerned, any application that comes before a community board initially, every community board application asks, what are your proposed hours? It's the biggest issue that we negotiate with community boards. So if a restaurant is coming before your community board and they say we intend to be open at 10 a.m. on Sunday morning and it's a 500-foot case and that's a deal breaker for you, well then you tell them just like 4 a.m. might be a deal breaker, 10 a.m. on Sundays is a deal breaker. That's something that go in the give and take. But if it's state law to enshrine one religion over another in 2016 is offensive, and I think we should take this opportunity to recommend that Sunday is no different than any other day and should be treated as such.
As much as I hate to disagree with Mr. Buckman, I would be remiss if I did not. There have been Supreme Court cases on this and subjects on this. This is not enshrining one, I don't care whether we have Sunday sales or not, I have to tell you, but this is not enshrining one religion over another. This is a question of American culture as it has developed. Saturday and Sundays are our weekends. Sunday is a day that has been set aside more than any other day in our society, and it is a question of people having the ability to sleep late and not be disturbed on one day a week, and it's not the enshrinement of a religion. So it may very well be a very good idea to do away with this. I personally support the permit system because I believe that every time one size doesn't fit all, and when you have a Bills game and everybody in the world wants to be able to go out, sometimes the people who want to sleep that late have to be disturbed one day a year, and New Year's Eve, when New Year's Eve comes out on a Sunday, and you can't give permits for New Year's Eve because it's Sunday, I think that you should be able to, but let's not turn this into a religious war, because that's not what it ever was or what it's about.
Well, I disagree. I think that is what it was all about. It's a Baptist, Methodist, prohibitionist restriction that is a total anachronism. And I can tell you this, I don't know any brunch in Brooklyn where I can't get a Bloody Mary or a mimosa Sunday morning.
I have to agree with Mr. Hindi and Mr. Buckman completely. It is an issue of fairness and equal treatment. We don't hear Mr. Buckman asking for us to limit the hours of availability on Saturday, or anybody else for that matter. This is, as Mr. Hindi points out, anachronistic. It is part of the old system. It has nothing to do with the way the world operates now. And I think if we were to continue to keep this restriction on the books, then we must also offer it to the Jewish community, the Muslim community, and every other community out there and recognize their right to have a day of rest too.
I can tell you, Borough Park, if you give them that option, they'll check 11 hours of service on Saturday. They absolutely will.
But we're all okay with the Giants game, right? I just want to make that clear.
You got to drink to watch them, for sure.
He just wants to call the round.
Okay, so what I'll do is I'll send a copy of that bill to everybody tomorrow. And then if you could get back to us to see what should be in the report as far as our position.
I think what many of us are saying is that bill is that bill, and that's wonderful, but this report should recommend elimination of Sunday restrictions. Yes.
Wait, is that the general?
We would like to do away with it completely, because I think we have brew pubs that want us to.
The general consensus.
That bunches.
I would object to it if you don't endorse specifically the permit bill. Your proposal won't get through the legislature under any circumstances.
And that was going to be what I said, I understand your point, and
I got no problem with that. I
agree with you 100%.
However, our recommendation is, for the reasons stated, that we eliminate it altogether. At a minimum, we endorse the legislation. We could do that.
We'll send out the bill, and then we'll draft some language in the report, and which everybody will see and have a say in. All right? Anything else on that one? Okay. The next one was the discretion in the 200-foot law. And that was an item that we did not discuss at the last meeting. It was an item discussed at the first meeting to discuss further. So now it's time for us to discuss it further. And whether or not the authority should have some discretion one way or the other to issue licenses for premises that are subject to the 200-foot law.
And I'm glad you put these two items right next to each other, because talking about anachronistic concepts, when Prohibition ended, the idea was that you can't have school children and church-going people, see people drinking alcohol, God forbid being on the same block, I think, that concept is long since passed. As Mr. Smith knows, this neighborhood in particular has been clamoring for years now for legislation to eliminate the 200-foot law, because there are so many standalone churches that qualify, and it is severely restricting where high-quality restaurants can open because they can't get a full liquor license. There was even legislation that had been introduced to eliminate the 200-foot law as it relates to full-service restaurants under the ABC law. Not bars, not nightclubs, not hotel lounges, but as a first step towards moving into the modern era. So certainly would be in favor of any discretion the liquor authority could have, in this matter. We often face with situations where the institution itself is not opposed at all, but it's still, liquor authority can't take that into consideration. But the fact that you could have right next door to a synagogue, a church, or a school, an establishment with beer and wine, but you can't have a fine restaurant that may not even have the same hours with a full liquor license, just shows, how silly it is. As all of us with college-age kids know, they do get drunk on beer and wine, So, the law doesn't even solve the purpose that the law was intended to solve in the first place, which was separate, So there is no discretion here. I mean, we've even had situations where there are nightclubs, that are within 200 feet, and they literally have not the same hours. They open at 11 o'clock at night. They close at 4 o'clock in the morning. The school opens, 9 o'clock in the morning. There's no commonality whatsoever, but it prohibits it. And in New York City, where real estate is tight, and there's a lot of finding a location for any business is difficult. A restriction like this seems a little out of date. So I'm in favor of anything that we can agree on that would help relax the 200-foot law, at least as it relates to restaurants.
Does anyone else have anything to offer on that issue?
Agreed.
Oh, okay. Do you think I know bills in the past have excluded New York City from the concept of giving the authority discretion.
That's the opposite. If anything, should be the opposite, because we're here, it's closer, you know.
It's one block.
Yeah, I mean, it's
200 feet, 200 feet is a city block. So you say if there's a school or a worship on a city block, that it closes out the restaurant. Either this makes sense or it doesn't. If it doesn't.
And of course, the community board would still be getting notice of any applications.
You could even say to notify the church. You know,
But I think they'd have to have some language in there.
There are some constitutional.
Well, I'm not suggesting they would have.
No, I'm joking. The Supreme Court has ruled that, or at least the federal courts have ruled, I don't want to that you cannot, I think it's the Supreme Court actually, that you cannot leave it to the church whether or not, you can't, if the church approves, then we can give it, because that is a separation of church and state issue. But there's no issue about allowing a church within 200 feet to have a say, you know, like any other citizen within 200 feet.
At least one of the bills that has been introduced in the past would require municipal consent, or in this case, community board consent.
I don't like a veto to a non-elected official.
Okay, I think, did you have something, Mr. Wexler? Oh, Mark, can you pass that down to Mark, please?
Really a question for Jeff. There are currently many licensees, restaurant licensees, that are within 200 feet of the church or synagogues, whatever, because they have beer and wine or just beer licenses they sell. If you have this legislation go through, this relaxation, will they get first crack at upgrading their license? Will anybody be able to upgrade? Is it first come, first serve? There'll be some kind of demarcation to allow these entities who probably took a step-down license to get where they are, will they be given some opportunity ahead of everybody else, or you don't really care? First come, first serve. Just kind of curious.
You would ask me?
No, I was asking Jeff, because he's the one, Mr. Bookman, because he's the one that, Rob. I apologize. You have been the one that seems to advocate this. Do you see a problem, or just see that it just be first come, first serve, whatever happens, happens?
I don't see it as a problem. I think some people might want to other applications. I don't see it.
Okay, just checking.
You also have others that are grandfathered. So, I mean, it's not like it doesn't exist anywhere. It exists all over the place.
But no, I understand Mark's point. You got a 500-foot issue. Do you give?
200-foot issue.
No, but there will be a 500-foot issue as well.
You get rid of the 200, well, you get discretion for 200-foot.
Right.
You then potentially have a 500-foot law issue. And kind of a spin-off of Mark's point, do you give the existing RWs, restaurant and wine licensees, first come, first chance at it? Because, or let somebody new come in and then maybe that existing RW license gets knocked out because now there are 3 full liquor licenses.
Not something I considered, but I have no objection if the legislature wanted to agree that for restaurants, we were eliminating the 200-foot law and to allow existing RWs 1 year exclusivity or 6 months, 6 months to apply. You know, I have no objection to it, you know.
Yeah, I would just say there's probably a public integrity benefit to this as well. In order to get a license issued that is within the 200 feet, you have to get a statutory exemption, and the statute is full of these statutory exemptions. And having been around for 30 years, watching them be lobbied and passed or defeated, I think we'd all be better off with a system that allows the authority to deal with it in the way that you're suggesting.
That's for sure.
Now, when I was a prosecutor, I would have just said, you just made a case for me.
Yeah.
There's a New York Post story. There was a New York Post story, I believe it's last year, about how much one particular applicant has paid, and then something about that advocate's professional representative and some of the tactics he or she might use. I think we'd all be better off with a better system.
And you're talking about limiting it just to restaurants?
I think there is historical, cultural concern about this, and I think a reasonable first step would be limiting it to full-service restaurants.
And what's the standard? We have to find public interest, we have to find, what do we find?
Well, I'm suggesting that we eliminate the 200-foot law as it relates to full-service restaurants. There is no standard. But if that's, you know, impossible.
It would just be public interest if it was a 500-foot case or a good
Right,
cause.
right. If that is impossible, because the legislature still likes to get paid to put in these special ones, as Mr. Wexler stated, then we need some sort of discretion that you would have to determine that, you know, it's in the public interest. I don't know, I'm not sure what your standards would be, but you could certainly, I think, ask, you know, getting input from the, you know, from the school or church would certainly be a factor that you could consider. Although, you know.
You could take into consideration the fact, you could just write into the statute that the liquor authority have taken into consideration the fact that there is a place of worship or a school within 200 feet may issue the license. You know, you have discretion on wine and beer licenses.
Good cause for that.
You have discretion on them right now, and you've been doing it for as far back as the wine and beer licenses were there. They left it out. It's never been that if there's a church or a school within 200 feet, we forget about it. It's always been something that you took into consideration.
No, there's case law. If it's not a 200-foot case, we can't consider the proximity to a church or school.
See, I was wrong again.
You know, in New York City, in any event, in New York City, most of them are going to be 500-foot applications. Almost everything is a 500-foot application. So you're already considering public, what's in the public interest because it's a 500-foot case. It will have gone to a community board. You know, you could look at things like hours, like I raised. Is there really hour conflicts? You know, does a Sunday brunch really? You know, would it interfere? I mean. At a minimum, we need to get, you know, there needs to be a way to make it part of an application before you, at a minimum.
And so, at least with respect to restaurants with full liquor licenses, is there a consensus that there should be a proposal to allow some discretion with respect to 200-foot law with those licenses, just with restaurants? Okay. The next item is additional branch offices for distillers. Rob, could you pass that down, please? Thank you. So under the current format, the farm wineries, farm breweries, farm cideries all can have 5 branch offices. The farm distillers can have 1. The branch offices, for those who don't know, is essentially whatever you can do at the farm location, you can do at the branch office. It can just be a retail, it can be manufacturing, it can be a combination of whatever you want to do. Whatever's allowed at your farm winery, farm brewery, farm cidery, farm distillery can be done at the branch office. So the question on the table is whether or not the farm distillers who are limited to 1 should be moved up to the 5 branch offices. And so this is one of the items that was raised at the first meeting. We have not discussed it in any detail, so that's why we're discussing it now. Any thoughts, comments, opposition?
Why were they kept at 1? Is that just something that hasn't been updated?
Because it's liquor, yes.
Okay.
That's essentially what it came down to, is that it's liquor. Now granted that the other branch offices, the farm winery, the farm brewery, they can all sell New York State labeled liquor at their branch offices.
We have wineries that have both, but they have, it doesn't make any sense why they should have more branch offices.
I would say that I think Bill, I'm not sure. There are very few farm distillers around there who actually have branch
I
offices.
don't know the exact number. Nobody has more than 1.
Right.
And there might be about 5 statewide. It's small, but it's brand new too.
So does anybody have a position one way or the other I'm assuming I know your position, Ralph.
Yes, you
Yes,
do.
okay.
How many do you have?
I have one, we have it on-site at the distillery. Oh, we have two, I'm sorry. We have one for our farm winery down at Woodbury. Right. But it's under a separate, but we've had.
No, they get a tasting room at your.
We have a tasting room,
Right.
but it's a branch office of our farm winery.
But what? But where's the farm, isn't your farm winery there too?
We have a farm winery, farm distillery, and AA.
But they're all at the same location.
Yes.
So you wouldn't need the branch office for the, we'll talk later.
But the point is, our position is that for distillers, we see no difference whatsoever. We regulate alcohol and control alcohol. We tax alcohol and control alcohol, not the rest of what's in there. And as far as we're concerned, there's no difference between somebody drinking a serving of wine or beer and a serving of alcohol, which the standard serving, all three categories have the same amount of alcohol in the glass. So we don't understand why we should be treated that much differently, that the ratio is 1 to 5. I mean, it should be at least closer to 5, but 5? Why? Well, I mean, 1, why? Somebody give me a reason that works, something, some real legitimate reason.
Anybody else want to be heard in this, or anybody adamantly opposed or adamantly in support, or?
You want it? You want it?
I want it.
I'm favorable.
We'll put language in the report for everybody's consideration, and then we can go from there.
Well, we'd like just to have additional language added to that says, because retail package stores are now allowed to taste spirits. And we'd like to remind those distillers that if they supply us with sample bottles, we can in essence become a tasting room for them.
It's not legal for them to supply you.
Right, there is a divisional order or an advisory that talks about a winery providing sample bottles to a package store for samples by the staff, the licensee staff. But a manufacturer can't be, for your tastings, the product you're using can't be something given to you by the manufacturer. It's got to be coming out of your own inventory.
They can come to you and taste their own goods at your store, but they can't give you goods to taste their goods in your store.
They're not there.
Right. I have no problem with this idea, but Ralph knows that he and I could have a long discussion of his comments about a standard drink.
Oh, I'm using the federal TTU standard.
That's what I was just
And
wondering
discus.
myself. How big are you?
I'm using the prevailing standards that are used by discus and by the federal government.
It's an ounce and a half.
An ounce and a half.
An ounce and a half of whiskey versus I think 4 ounces of wine versus 8 ounces of beer. Will generally have the same amount of alcohol.
Right, but that's not I'm assuming the tasting amounts are relatively the same in all three.
Actually,
No.
the tasting statute.
For spirits, it's
the tasting
0.25.
license, has quarter ounces for spirits and I think it's.
Show me a Manhattan or Martini in New York City that's 1.5 ounces.
You show me a Manhattan and I'll murder the bartender.
You do have something?
Yeah, I just want to say, very small. I'd be a little remiss if I didn't say that, with each one of these branch offices, they're entitled to sell a number of products in addition to spirits. And the more you get out there, I forget what the list, but it's cheeses and what have you, correct?
Essentially locally grown
and everything. Mm-hmm. And again, as representing supermarkets, we would prefer for people to come to our stores, and the more, I certainly don't object. Think it makes sense to allow distillers to afford them the opportunity to open 5 like everyone else, but I'd just like to point that out.
Okay, the next item was, and this is again an item that was discussed at the first meeting, or at least raised at the first meeting for further discussion, is channel pricing. And for those of you who don't know what that is, we're talking about.
I thought that had Chanel pricing. I thought we were getting into.
Did I spell it wrong? Yeah.
No, you spelled it right. I read it.
Now I lost my train of thought here. for liquor and wine, being able to have different prices, different retail prices for on-premises versus package stores and wine stores. That's essentially it. It's essentially for the wholesaler to offer different prices for on-premises retailers versus off-premises retailers.
To allow that.
Right, to allow that. Right now, they all have to pay the same price, or the same prices are available to them.
And what's the policy reasons behind allowing that?
Buy differently.
What?
This was, I think Mr. Eber was in favor of this, but they buy differently. Restaurants don't buy in the bulk and get the quantity discounts that package stores get.
But there are quantity discounts now that you don't need to change.
I can explain this. By explaining it doesn't mean that
You got like 2 minutes.
No. I can explain this, but by explaining it doesn't mean that I'm pushing it. I'm just explaining it, okay? There is a concept that you go into a restaurant, you buy a bottle of wine. You buy that bottle of wine and you like the wine, and the sommelier comes and recommends that wine to you. Now you go to a package store and you say, you know, the other day I had this bottle of wine in the restaurant, which has a limited wine limit and is picked, and I want to buy that wine. So the people who make wines, especially, want to get their wines into restaurants, and they particularly want to get their wines into restaurants and sold by the glass. So there is a concept that says, if I can get the wine in, this is my advertising. The restaurant is my place to advertise. Wine by the glass is my place to advertise. I'm willing to take a lower price as a supplier for wine in a restaurant, because if you come into the package store, as the average consumer in America doesn't know what they're drinking, otherwise we wouldn't have had the whole discussion about wine products. If they knew what wine products were and what wasn't what they think is wine. So now they go and they say, okay, now I had Bookman Elite, and I go into the package store and I say, hey, Bookman Elite, and they say, no, but I have Bookman Standard. And because it's Bookman, they buy it. So I'm pushing the goods through the on-premise and through by the glass and on-premise in order to get the goods into the package store, and it's worthwhile for the supplier to have a lower price, because getting into the restaurant is where I want to be. Also, restaurants generally don't have room, whereas package stores generally either have room or have a warehouse. So restaurants can take advantage of package stores can take advantage of quantity discounts more often than restaurants can. So the restaurants are buying, just to fill in by the bottle, whereas as the package store is buying in quantity and getting a lower price that way. And the third thing is that once you're on a license, you want to stay on that license. I mean, once you're on a menu, you want to stay on that menu. So if I've sold to a package store, I want to be able to, and I'm running out at the end of the vintage, I want to be able to continue myself in that restaurant and stay on that wine list. People don't come in and ask for the wine and they don't have it, or I get dropped off the wine list. I want to be able to stay in that restaurant, whereas the package store will buy the goods when I have it and can sell it to them. The package stores generally take the goods in the beginning as soon as they can get them and take the best price they can. The restaurants are usually taking them over a period of a long period of time, over the entire year, because they want to just have enough to sell as they don't want to inventory up.
So
those are the reasons.
So you see this as an opportunity for restaurants to buy at a lesser posted price than?
Well, in most cases, what would happen is the lower price would be on-premise.
Would basically allow a consumer to taste a
sample a high-priced wine that he would not go into a store and be able to buy, or would not want to invest the money, but it would be a sampling for him. And it would be probably a wine that he would never have spent that money for if he hadn't tasted it.
If you want to hear the other side, I'll tell you.
Thank you. The argument being made in favor of this sounds just like the argument that was made 27 years ago, before we had quantity discounts on liquor. So we're going to oppose this. What we would suggest, I notice at the first meeting, I thought we had consensus at the request of several of the retailer members to discuss other buying issues, co-op buying or retail to retail. I see they're not on the agenda. I understand that we're not likely to talk about them in this venue. So what I'd suggest we do is, separate from this project, I'd like to ask the authority to host an industry meeting to discuss issues about wholesaler, retailer pricing. Have an open dialogue, discuss what issues, see if we can develop consensus, or at least have an honest, substantive discussion about why we don't agree, and then at least the conversation will be informed and thoughtful, and people can advocate what they think and what they want to do with that understanding. But Channel, I'm not going to make the same mistake I made 27 years ago when I agreed to the wholesaler's request for quantity discounting, and now my small taverns pay more for a bottle of liquor than they can buy it at a liquor store, which is why they want to buy it from Tom's members. It would help me if the statute only allowed channel pricing if the prices were lower. Mark asked me a moment ago in the sidebar whether my folks do bill and hold. We don't. But again, that might be there might be other ways to solve our problem, and that would allow us to support an approach that Lester and his client and others were advocating. But it's not a consensus.
So you're saying it's too complex right now to get it?
Thank you.
All right, next.
You pass the,
And we'll talk about having an industry group about that.
Thank you. We would support that too.
But just for my own edification, where do you stand on that?
Tom, do I understand correctly that you and your members want to have a conversation about co-op buying and retail to retail?
I think retail to retail more than co-op, but we'd like to see more clamping down on co-op buying, but I understand it's a tough issue.
Hey, Rob, I wouldn't know that Kevin's never used the word diner and elite in the same sentence. All right.
Or anybody else for that
matter. Tom, don't worry, in his example, the Bookman Standard was selling better.
Next item is sale of gift bags by package stores. This is another item that was mentioned at the first meeting and held over for further discussion.
Aren't they allowed to do that?
They are allowed to sell now, but they're not allowed to have any profit in it.
Because otherwise it would be considered otherwise it's considered a business, which is not allowed by the statute.
I get it.
First, let me turn to it's a package store issue. Let me turn to Tom first. Do you have any comment on it?
We'd love to be able to turn a profit. This is the whole idea of the.
Now, will there be price posting so you only can sell by certain? Yeah, we're all in favor of it. Somebody had a comment over here? Okay.
No, we're not going to argue over this issue, but it is an expansion of beyond alcohol, but I think it's closely enough related. And if someone can remind me, is glassware able to be sold?
Yes.
Yeah.
Wine glasses.
Wine glasses, right.
It's referred to as stemware.
Stemware, that's what I meant. So, okay,
You can't sell.
I don't mean to, but the statute says wine glasses. It doesn't say stem glasses. And there are many wine glasses out that are not stem. So, while you might refer to it that way to make people understand that it's just wine glasses, the Riedel. Jeez, excuse me. Riedel sells a whole new set of wine glasses that have no stems, and they're still legal.
The statute talks about glasses designed for the consumption of wine, which I found are also very good for the consumption of liquor, too.
In my household, it's a good
So, with the understanding that we're looking at just at items that are associated with,
And, well, this item in particular, and allowing it to be sold for profit.
Would charging for gift wrapping be different than selling gift bags?
Charging. I'd have to think about that. I mean, how do you wrap a bottle of wine?
In the bag?
Just
charging.
Like a Mylar.
Yeah, they don't charge for them.
Would you want to? No. Oh, you wouldn't want to charge it?
Could we also add onto that list rocks glasses and whiskey snifters and tasters? Because those are also.
Here we go.
Well, I mean, it's only fair. I mean, why, Tom's store sells more than just wine.
Yeah, but for the purposes of this meeting, I mean, I could take it back, but.
I guess my point is, if we're making some change and an allowance for wine-related glasses, that change.
We're not. This is, that's already there. What we're talking about now is allowing the package stores to make a profit off of the gift bags.
Just gift bags.
We were just talking about glasses.
No. There was a discussion about what they can sell, all right? And whether or not stemless versus stemless, that's not an issue. This is solely with respect to whether or not a package store can simply charge more than the cost for a gift bag. That's it.
Which they're already selling.
Yes.
See, here's the problem with this.
Let's start off with the fact that it's probably completely, there's the list of things that a package store can sell and can't sell is arbitrary to begin with. So, you add gift bags or you don't add gift big, you're not changing the world. It's just, and it's a natural extension of what package stores sells. There's no real reason not to allow them to sell it. But here's the thing what I was going to say. You say, right now there's an advisory, it's not an advisory like we talked about earlier, but it's on the website of the Liquor Authority. It says that you can sell gift bags as long as you don't sell them as a profit. Well, I started off as a CPA, so the first thing I would say to my clients is, what's profit? Because if you throw overhead in, right? You start off, you throw your overhead in. You don't have to start with, I bought this for 12 cents. I'm going to sell it for 12 cents. I bought it for 12 cents. Now I have heat, light, electric. That's another penny. I have rent. That's another 3 cents. I have my staff. That's another 5 cents. Now I'm selling it for 25 cents, and I'm still not making a profit. So this whole thing is, it's an arbitrary thing, and unless you have real reasons why you should feel strongly against somebody selling bags and it's going to make a difference in your life, there's no reason for anybody to be against it.
I know, but he had these good things he wanted to say anyway.
You just used up the last of your 2 minutes.
Go ahead. Wait, someone get back.
The gift wrapping, as well as the opposition. In my store, we have bags and we also do boxes and gift wrapping. Would there be any opposition to do it?
I don't think so. No.
And then Mr. Kozlov wants a microphone.
Did you, Mark, you had something to add? Did you? I didn't think so. Okay. All right. So the last item on the list that I sent to you all is this, related to your situation, is allowing an entity that has an on-premises license and a grocery store off-premises license for moving the liquor through the grocery store license to get to the if there's a storage unit in one place. Maybe you want to explain in a little more detail for everybody so we all know what we're talking about.
Yeah, there's some locations where there's 2 different licensed premises. As Tom said, you've got a grocery store and then an on-premise license in the front of the store. And, it's in accordance with all the rules, regulations, laws. And deliveries come into the back, and they want to be able to bring a a couple bottles of wine, a case of wine, what have you, from the dock in the back to the on-premise in the front, and right now they can't do that. They just can't simply walk through another licensed premise.
What are they doing now? Walking around the building?
You gotta walk around and come in the front, or they say that, and that's where customers are coming in. It's
simply because there's a provision in the ABC law that says that, with an exception for certain manufacturers, you can't have any product on the licensed premises that you can't sell.
It reminds me of the provision, the 1069.
Sounds silly.
Yeah.
Does anybody have nobody strongly opposed to making a recommendation that get changed? Okay. All right.
Nothing, Tom? Nothing. You're good? Good. Okay.
All right. Now, this wasn't meant to foreclose discussion on other matters. We went through to try to find the items we thought they'd be. Yes, Paul?
I'm sorry, you finished. I have another matter.
Yeah, and so, at this point, do you want to Chairman, you want to turn up into any other topics that the group has about other issues that we raised, preferably that we raised at the first meeting that we haven't gotten to yet? I know Scott mentioned a couple that we haven't gotten to yet. We weren't sure how long this meeting, how long this would take, so we didn't want to list everything. So, among the group, if there's issues that you think there'd be some consensus to resolve, feel free to raise it.
Well, we had one issue that I brought up in the first meeting, and that had to deal with the temporary beer, wine, and cider permits. With the number of event producers that have moved into New York State, putting up these festival in a box, as I've termed them, and all they have to do is go to a wholesaler and buy the product, set up, pipe and drape, and have a couple volunteers at a booth, and they have a beer festival. And I'm getting pushback from a lot of breweries in the state that are at these beer festivals, these for-profit beer festivals, and don't even realize that they're there. So not only is their product being sampled, but their brands are being represented as well. And so we would like, if possible, if we could add to the language somehow that permission has to be granted from the breweries in order for them to be able to pour and sample their beer and use their brands, for that matter. And I don't know if that's simply adding something to the Brewfest requirements.
You're talking about anybody who gets an ST permit, I mean, a temporary beer and wine permit. I'm not sure, because I don't know how many thousands of those we issue.
A lot, because there's a beer festival every week, and yeah.
Those permits don't just cover.
The temporary beer and wine permits don't just cover beer festivals. They cover, the community events, the volunteer softball tournament,
I understand. I guess I'm just talking specifically to these events. We just need to put a control on it somehow. There's so many of them, and I think brands are being poorly misrepresented, and our brewers are upset that a brewer in Buffalo's beer is being poured at a Binghamton festival, and they need a for-profit festival, and their brand is being represented poorly. And it's just so easy to do. So I don't know if there's something that permission should be granted, I think. I don't know if our friends at the larger breweries would care if their brands were being represented, but I think that they would if they didn't know.
I'm just not sure as far as drafting something.
I think our agency, as he said, does not differentiate between a beer festival and goes after
so that's the
softball
challenge.
Party. So that would be an enormous challenge.
Yeah.
We'd actually have to make a new permit.
Okay.
Probably, that's the only way to do it, right? For a beer festival.
Well, not only that, we'd have to create a new permit and then restrict those entities from getting the permit that now exists.
Yeah, we're just trying to find a way to, it's the Wild West out there, and these brands are being poorly represented.
I mean, they have to buy from the wholesaler.
They do have to buy from the wholesaler, but, they're using their breweries on their advertising for profit to make, and these breweries don't even know that they're at these festivals. They just, and they're putting volunteers, so they're not only pouring their beer, they're misrepresenting the beer and the brand. And it's.
Have you sued them?
Well, no, I mean, that would be, I've had brewers actually buy up their product from the wholesalers to prevent their beer from being, but that's a pain. They literally buy up the product one day and then give it back the next day so that these festival producers can't get their beer.
I'm confused. You have a brewer who sells to a licensed wholesaler.
Correct.
Who sells it to a...
To you and me, if we want to do a beer festival. Right.
And I'm selling, 5 different beers at that beer permit. And the original brewer doesn't want the beer being sold there?
It's not being sold, it's being sampled. So in other words, yeah, so you and I, you want to do a beer festival, you go to a wholesaler and you set it up and you advertise, you have 20 New York State breweries, and cideries and wineries and not a, and you can buy from the wholesaler, sample, put up a sign that says, Brooklyn Brewery is here, put a couple of volunteers in the booth, and he might not even know he's at that festival. I see. And so that's, there's just a couple of volunteers. What is this beer? I don't know what this beer is. It's just an IPA. Are you with the brewery? No, I'm not with the brewery. But they're using their logos and they're using, and so I just didn't know if it was something simple could be done. And that's kind of what I'm asking. Yeah, okay.
I don't have I just want to embrace the problem. I want to tell you from an on-premise, particularly upstate, we see it as unfair competition. And we're proud when our brothers, our suppliers do this to promote the brands, then they come in, but this is going on, so again, I don't know that we have an idea here, but we would encourage folks to work together to try to find a way. They're basically fly-by-night retailers is what they become. From us, it's competition. For communities, it can become alcohol-related, like a party downtown that they didn't anticipate, doesn't have any rewarding value other than the profit for the sponsors. So we would like to work with you and encourage the authority to try to find some solution to this.
Thanks, that's great.
My understanding was tastings was a my understanding was that the whole concept of tastings was to help producers get their product out, and it's free tastings in small quantities. But originally, I thought you were saying is you objected to people actually selling, glasses of,
But they're selling tickets to the event.
Okay,
Yeah. So
based on what you're saying, the problem is why can't the solution be that no tasting is allowed of a product unless the permission of that manufacturer.
You can't do.
You can't stop them from selling a glass, an 8-ounce glass of wine, but the tasting is different.
No, but what you could do, excuse me. I have no horse in this race, but what you could do is you could, with all permits, you could put into the permit that while they have the permit and they can sell the beer, they can taste the beer, they can't use the logos, they can't put up logos and signs of manufacturers without their permission when they use these permits.
Part of the application.
It's the condition of the permit. And if they do that, then they don't get a permit the next time. It's one thing to say, I can't go into a C licensee, buy the beer under my permit, and go out and sell it, because that's what the permit is for, and it's for everybody. It's another thing to say that while I'm doing this, I'm going to set up a booth as if I represent somebody. That's false advertising. If I'm using their logos and stuff like that, even if I say I'm going to taste 50 beers and put 50 beers out, it's different than putting the logo up, the logo's on the can, but putting a logo and put up a sign up, as if I had the right to put that sign up without permission, is, that's something that you could restrict on your license application.
I think we'd have to do it.
For everybody.
Regulation.
But when the bar puts up a Budweiser, what a bar can't do is put a Budweiser sign on a tap that serves peels. So, if they're putting up signs and they are misleading the public into thinking that this is a tasting conducted by the beer manufacturer, then it's a question of misleading the consumer, and that's a different thing. And you can condition the permits any way you want, as long as it's for everybody and everything. So if you said, okay, you have the permit, go out and sell it, go out and have your festival, but don't put up signs that say this is Bookman beer, unless Mr. Bookman, it gives you permission that to use that sign in that location. That you could put that on your permit if you wanted to.
Well, I think that's something we could also.
How are they getting the signs from the wholesaler?
Yeah, they usually, no, they just print them up themselves. I mean, they're festival companies. This is a big business, and this is why they're doing it, because it's huge profit.
And it's in their advertising as well.
I'm sorry? Well, sometimes they won't actually use the logo, but they'll say Brooklyn Brewery is here, and they'll print their own,
they'll just say Brooklyn Brewery on it and hang the banner over the booth. And they might not use the actual B, but they'll say Brooklyn Brewery is here, and they'll buy their beer, and it will be Brooklyn Brewery's beer, but they just they don't even know they're at these festivals. I just feel like the manufacturer should say yes or no, or have the right to say yes or no. I don't want my brand represented in this way, or misrepresented.
Well, I mean, that's one of the statutes where we do have some regulatory power, and it's maybe something we can look at through a regulation rather than a legislative change.
General rulemaking, we could do it that way.
No, but we actually have it for that particular statute.
General rulemaking.
Were there any other topics, anybody? Yes, Tom?
So we will look at that as, on a regulation.
There were two issues that we talked about at the first meeting that have not been on the agendas yet. One was the ability to buy more than one combo kit per month.
And the other was in the licensing for package stores, there's verbiage, public convenience, and we were going to try and codify that through a discussion.
Going back to the second one first, we had talked about the idea of putting some language in the statute with respect to not only public convenience and advantage, but public interest and good cause. I know there was some concern.
What's the second one?
The two issues tell me that one is codifying what public convenience and advantage means for issuing a package store license. And the second is the limitation on the combos, which I think is a matter of administrative for the authority to look at, because that's been done through an advisory. But for the second one,
Well, let's start with that one, because is anybody against that? The combo packs?
yeah, there was a lot of discussion. When we went through this, there was a lot of back and forth on this.
So go to the second one.
So,
I forgot about that.
okay. The second, we did raise the issue at the first meeting about whether or not essentially the three standards for issuing a license, good cause, public interest, and public convenience and advantage, should be defined somehow in the statute. And we talked about that briefly at the first meeting. My recollection is there was some opposition to, because kind of going along with what Mr. Dano said earlier, is that once you put something in the statute, does that kind of restrict you as far as what you can do when you're looking at an application?
Definitely.
Does anybody have any thoughts around pursue that?
What's your thought on it?
Well, as package store owners, and I appreciate Mr. Dano has a concern about it, but it's not clear to us when other applicants are applying. It seemed to be used kind of willy-nilly, and we don't see a consistency in how the licenses are granted and how they're denied. And that's really what we're trying to drill down into.
The problem that I have, being the one that grants them, is that it's very hard to have a level of consistency, because you're talking about a state wherein every municipality is so different. And, and I was just talking, I don't know who I was talking to, walking in here, I forgot. It was Mr. Bookman regarding liquor applications in New York City. I walk out of here most hearing days feeling awful about myself, because I've rejected 9 out of 10 liquor store applications within the boundaries of New York City. And a lot of it is because of saturation, or what I see as saturation, whatever the case may be. That is not the same case upstate or Buffalo or wherever you may be, but there's other factors that are taken into account that are not taken into account down here, such as how many square feet of liquor stores are there within a mile or 2 miles or whatever we may be thinking about, because the stores tend to be a lot bigger when you leave the state. So that's my concern about putting an exacting standard on public convenience and advantage, because I think it is different here than it is when you get to, say, Binghamton or Rochester, or even in the rural areas. That's just my take on it.
I think, I think that having been at 4 board meetings and listened to a whole lot of these presentations, which take up, I think, 80% of the board time, which, in and of itself is a bit crazy. But having heard all the presentations, having seen denial letters, and having done, occasionally, liquor store, myself, sometimes approved, sometimes not, I think they've developed, like the court does with case law, a pretty clear guidelines, if you will, that when a client walks into my office and says, I want to do a liquor store, I know what to go over with them. I know what to say that they're going to look at. We're looking at proximity. We're looking at what's different about you than anybody else. We're looking, are you closer to, do you have parking? Are you closer to a supermarket or a Subway than the others? So I don't think it's willy-nilly. It's clearly not a clearly articulated statutory standard, which I don't think you could do for a state of New York. But I think it's pretty good, and I think your court record on I don't know how often you've been challenged on denial on liquor store, but I think it's pretty good as well. So
That's because the law challenges.
yeah.
Pretty good.
I mean, I have larger questions, coming from mostly the on-premises world where we have a restaurant row and stuff, and I believe in capitalism. I'm not sure what the whole concept initially was about why liquor stores should be so restricted, at all. But it's not my issue,
Well, I look at it the other way. When public convenience is used by the applicant as an argument as to why they should be granted this space.
And when I look at New York City, or I look at the density of a Rochester or a Buffalo, and we're still granting licenses to very large stores when there is already, to your point, saturation in the marketplace, and the reason is because it was a public convenience. That is sometimes difficult for my members to swallow. They don't understand what that means when a new applicant is granted a license for that reason.
I understand, but I think also that the courts have indicated what factors, as he just mentioned, go towards public convenience.
At the end of the day, it's public.
That's the only
thing. I think they do a good job, but it is the public convenience. It's not, with all due respect, it's not the convenience of the nearest liquor stores, or, I don't even know why they look at, a sale numbers, to tell you the truth, because to me that has nothing to do with the public convenience, but they do.
They look at them to see not if there's an impact on the existing stores, but whether or not there's, is the demand in the area, going up, or is it decreasing? It's not.
You can argue that you can argue sales are going down. Maybe they're bad retailers,
and we do get that.
And we do get that. They're bulletproof stores in a store that's become gentrified.
All those arguments are made.
But they're all made now. I mean, I think he's right, though, and I think that the number of applicants that are approved now is dropping dramatically. It seems to me, just anecdotally, in the last couple of years, and I think. Yeah, more than anecdotally. So I think we'll probably go back to the era pretty soon where if you want to get into the business, probably your first stop is try to buy out somebody else rather than try to shoehorn yourself in, on a block that doesn't have one.
I've been around long enough that I can predict that.
Is there anybody else, the members of the group that want to raise any other issue that?
Well, no, we still didn't talk about the combo kit, is that?
Well, no, I think that's really an advisory matter to discuss as far as amending the advisory.
I would like to see, just at the last board meeting,
At the last board meeting, the chairman and Commissioner Kim disagreed, and because we only have two commissioners, any disagreement is a no. I would like to see something in the statute that, it happened. In fact, you said, I would vote for you, but it doesn't matter how I vote because it's already known. So I would like to see something in the statute to have the ability to have a temporary commissioner during periods of time until a new commissioner is appointed, so that we have always three.
Or a tiebreaker in that event.
Tiebreaker, we flip a coin? No, we get the CEO. The CEO gets a vote, man.
No, I made a suggestion which at the last meeting was not, was taken as something that could never get passed, but if there's something that we could do, that during those periods of time, because frankly, this has been an extended period of time because of other problems up in Albany, which I understand, it's not the authorities' problem, but there should be some way to deal with the situation when there were two commissioners.
I don't think anyone at my side of the table is against that. I don't know what the solution is. Give the governor temporary appointment power?
They can't appoint a commissioner, they're not gonna make a statute about it.
No, that would. That's a good point. No, but it certainly would work for me that during a period of time that the governor appoints a commission until the Senate.
That they'll never agree. But seriously, they could agree that in the event that they could agree, perhaps, that during periods of times where there are an even number of commissioners, that if there is a tie, seriously, that the CEO that the CEO gets a vote. I mean,
We don't have a CEO like we had for many, many years.
then I get the tie-breaking vote.
I mean, I guess the one thing we can do, and I think that the governor's office is in agreement with this, is at least commit very strongly that something's done.
Right.
And not really define what that is, or put all the suggestions in there.
But right, it's not fair that two commissioners in a tie vote, you lose. Especially if it's chairman's year, yes,
Or the
that should count for 1.5.
You theoretically
Could you?
You could theoretically say that in the event of a tie,
The
chairman's vote counts. You could say that. Why not? I mean, I'm not saying that you should. I would like 3 commissioners. I mean,
I would too. I'd like 8.
7.
Well, there was
5. All right. There were 5. Yeah. All right. Anybody else on this side of the table have anything? I'm not gonna. What about on this side? We'll go down to. We'll work our way down. Steve, I guess is first.
So we're gonna leave that at that you're gonna just write strongly that we need some second.
strongly some solution to tie votes.
Or the lack of a commissioner for an extended period of time.
I just wanted to make sure the issue of mixed case shipments, is that still on the agenda for next time? Shipments of wine from within a region, from within a 50-mile radius, that could be put.
What Steve is talking about.
Yes, you do. What was proposed before was to allow wineries within the same region to put together their shipments and send them.
What Steve is referring to is that wineries in New York State and out-of-state wineries can ship directly to consumers, but only the wine that they produce. And I know the wine trails particularly have sought permission to allow the wineries to ship not only their own wine to consumers, but it's maybe like a sampler pack of 6 wines from 6 nearby wineries.
It doesn't seem to make sense that under the statute, a farm winery can carry other New York branded wines. They can actually transport other New York branded wines, but they just can't ship them to consumers that come in and taste them and want to have them shipped home.
The caveat to that is that if that were allowed for New York wineries, everybody can do it.
But everybody seems to be doing it now. I mean, you have the New York Times Wine Club, the Wall Street Journal.
But the
consumer doesn't see.
Those are retailers. We're talking about the out-of-state wineries doing it through a direct shipping permit.
We discussed this amongst ourselves a couple of weeks ago, and people said we really don't have a problem with competition from California, because if we did, we probably wouldn't be in business right now anyway. But
how do the retailers feel about that?
We really don't want to see an open, fair game shipment.
I think we should be going in the other direction, finding ways to stop people from shipping into New York illegally.
All right. Did you have another?
I did. Something that came up recently is BYO policies, is that, or bring your own bottle, is that illegal?
It is if you don't have a license.
Yeah.
Always has been.
What do you?
A consumer comes in and pays a corkage fee?
You can bring your own bottle into any place that has the.
Your 2 minutes ended, okay? Like 5 minutes ago, okay? There's a bottle club statute. If you're going to allow people to do BYOB or give out your own beverages, you have to have a license for that. So a restaurant that allows somebody to walk in with their own bottle, if they don't have a license, they're breaking the law.
If they do have a license, they can. So the kind of beverage that's being brought in.
So what's your question?
Somebody wrote to me and said, please bring up the fact that it should be legal to bring your own bottle.
It'll be legal if they get a license. It's simple as that.
I think I'm talking about consumers buying a bottle at the winery and then taking it to a restaurant that charges a corkage fee.
And that restaurant can get a bottle club license and.
If they have a license,
If they're already licensed, it's not a problem. It's
legal. They can allow somebody to bring in a bottle of wine, you can charge them a corkage fee.
This is a problem that doesn't exist.
I withdraw the issue.
Okay.
And they don't even have to charge a corkage fee, right?
No.
But they can.
Jean Marie, I think you had something?
It's less of an issue and more of a question. So 101C, we all know suppliers can't directly or indirectly give gifts to retailers. I'm wondering, do we have anything where it addresses the fact pattern of retailers requiring payments? Yep. I haven't really seen that, and it's really a question because nationwide and in other states, there are some.
Statute's reciprocal.
In the rules of the authority, there's a provision talking about just that, all right? And also in the consent orders that are now almost 10 years old now, there's actually provisions in there about that, because that's one of the things that was investigated, was not the manufacturers coming forward with offers of payments, but the retailers demanding something to put the product on the menu.
Those actions were against ultimately it was the manufacturers and suppliers who ended up.
And now there are some retailers that there are 3 consent orders, and they cover them all.
Oh,
Yeah.
right.
Mm-hmm. So.
But the retailers weren't fined.
But that's not in the law then, though. They're in the
Right, but
regulation.
there is as Kevin mentioned, in the rules of the authority, there's a reciprocal provision imposing an obligation on the retailers not to be involved.
Do we want to consider putting that into the ABC law?
Is
it a problem?
I think I've seen it. It's
I mean, we can go after
larger,
them now under the rules.
a larger issue. I think the way New York is set up, we're perhaps not seeing it as frequently as perhaps in some other states. And I know on a federal level, they're taking a look at when there are large chains that are requiring payments, and I think that's we're seeing much more of that.
You can go after them now, as he said,
Yeah.
so I'm just not hearing that. This is the first I'm actually hearing that.
Well, if they requested and it wasn't paid, we can't because we don't have
Right.
intent
Food for thought.
Ralph, I think you had something?
Yeah, we have, for the craft distillers, I'm not talking about just the farm distillers, but also the A1 distillers, the craft micro licenses. The best way to introduce a product is to sell it, to offer it as samples and sell it right at your brewery, winery, distillery. Under current law, I can sell anything that I make with New York products at my distillery, which means that I'm unlikely to try making products that are other than that, like rum, for instance, which is traditionally a New York product. But also on the other side, the A1 producers are not allowed to sell their own products in their own site of production, unlike breweries and wineries, whether they make the goods, no matter what they make it from. So if they're making something from 100% New York raw agricultural materials, they can't sell it at their location. So the restriction of only allowing farm distilleries to have a sales opportunity and tasting opportunity at the distillery or at the farm winery is not of benefit to either side, either the producer or the consumer, because the consumer doesn't get introduced to new products. I know when I put out a new product, it's almost impossible to find a distributor who'll pick it up right away because there's no track record whatsoever. Whereas if I can sell it in my own store, I can show a distributor that's just selling at a certain rate. I can see that it's successful and worth the investment it's going to take to bump it up. And for the A1 distilleries, many of whom are making rum, which was very traditional in New York, they're unable to introduce their products to visitors, which eliminates the tourism aspect of their business, and it also eliminates their most convenient and accessible way of getting their product introduced to the public, which is selling it to them right at the place that it's made. So what I'm asking is that the authority consider a change that would allow any distiller to sell anything they make at the site of production. And that would allow the farm distilleries to extend to things like rum, like I said. And it would allow the A1 distillers to have a place to distribute their goods to the public and introduce new goods.
Just for purposes of background, with the Craft Beverage Act of 2014, all manufacturers, except for the distillers, the rectifiers, and the fruit blending producers, but all the wineries, breweries, cideries, and the farm distillers can all sell the products they make, by the glass and by the bottle, and do tastings at their licensed premises. I think, Ralph, you're suggesting that be extended to the micro distillers.
It should be extended to the micro distillers, but by the same token, on the other side of the coin, the farm distilleries should be able to sell anything they make in their distillery at the site of production.
Well, they can.
The farm distillers can't make, that's right, they can't, what I'm saying is that they should be able to, yes, I see.
So if they have two licenses, you mean?
Yes. All right. For instance, we have an A1 in a farm distillery. We made a rum. The reason we didn't continue to make it is because we couldn't get it out to the public and make it.
But the way to do that, though, would be to extend the privilege to the A1 license.
The privilege?
The micro distiller's license.
For the sale and tastings, yes.
Mm-hmm.
How many A1 distillers?
I don't know.
There's a lot. As many as there.
There's a lot.
The idea would be that.
Farm distillers is probably the same amount.
But is there some reason why we couldn't specify?
They want us micro or full?
Well, whatever micro.
Micro's up.
Are we talking about?
We're talking about micro distillers. And actually, there's only a handful of full-blown Class A distillers. Mm-hmm. Yeah, that's.
What'd you say? It's not gonna happen.
So if you just extended the right to sell and do sampling at the distillery.
You can put some language in the proposed draft and see what the group thinks.
Well, I'm kind of interested what they think now. Is somebody against that?
I didn't think there was, but I didn't see anybody. I know there's some of the group members up in, at least one up in Albany, and I just want to make sure that we don't pass over them before we.
No, I'm good. I'm having side conversations with Paul, getting caught up, and then I'll follow up with you, Tom, about what I missed, but I don't have anything to add at this point of what hasn't been on the list.
That's Steve Harris, ladies and gentlemen. Steve, did you miss the discussion about the beer festivals?
No, I was here for that.
Okay.
Yeah, Buffalo here?
Yep.
Did you people resolve the issue about us wineries being allowed to ship other people's wine at the same time? I didn't hear it.
Yes, it was resolved to the extent that there wasn't an agreement that it should take place.
It should take place. Okay.
No,
Thank
it
you.
should not. It's not going to be a recommendation from the group.
We would be in favor of that happening.
Yeah, we're certainly in favor of being allowed.
I understand, but there's a number of members of the group who were not in favor of it.
I didn't get that from people. We have customers that come in all the time with 4 bottles of wine, and they're asking us to ship wine. So we say, sure, we'll ship it in a 6-bottle carton, but we're not allowed to. What's the problem?
I think that the retailers are opposed to it?
Well, excuse me.
Wineries are in favor.
The wineries are in favor.
Unfortunately, Mr. Edwards has left, so, okay. That's, Chairman, that's everybody with the group.
Does anyone have any other issues? Public? Anybody in the audience?
All right, so,
So I guess,
So Tom is going to head back to Albany immediately, start typing. And I'm not going to hold him to a date, but the next meeting is February 3rd, as I said. You will get a proposed report, pardon me? Yes, it's here, and we'll also have Albany and Buffalo. You will get a proposed report. And this is directed at Mr. Bookman, I ask that you do your homework before you come in the next time. And we will discuss changes and whatever, to hopefully get to a final product at the end of that meeting of something we can hand up. So thank you for coming today, and have a good day.